Good morning, everyone.
Good morning, Judge.
Good morning, Judge.
Morning, Judge.
Yes. Are we ready to start? I see some people are still in the lobby. Yes, Mr. Late? Are you saying something? Good morning.
Good morning, my lady. Your ladyship won't believe it. This morning my computer automatically downloaded updates and now it doesn't want to start again. So we're going to proceed with only this one computer, and Ms. Marriott will continue with as witness. I would like to address the court as soon as my computer is back online to address the court on certain issues that came to light last week with certain correspondence that we received, and I would like to address the court thereon as soon as my computer is back online. In the meantime, my little friend, if everybody's ready, we can proceed with the evidence of Dr. Makachwa.
But before we go there, we need to know as to how far are we in relation to where we left.
Yes.
Yes, Irene, we are not yet on record, ne?
No, Judge, not yet.
Okay. Yes, can we deal with, there is an issue that I want to deal with. Apparently, there is a letter that Irene received, my registrar, which indicated that, in fact, it's a complaint that there are documents that are being uploaded on Caseline. So we need to agree as to what should be done, because people shouldn't just upload documents. Otherwise, it's going to disturb the pagination of the documents that are already there. It's going to interfere with that, because when the documents were uploaded by the evidence leader, I specifically indicated that they should be uploaded in sections so that we should be able to locate them without confusion. Now, the documents are already paginated. Whoever wants to paginate, I don't know, but I should think that they should communicate with the evidence leader so that in case that is something new, which is not already on record, it can be properly paginated.
I agree with you, my lady. All the people on Caselines has the permission to upload and remove documents, but I really request from the people not to upload any document or to remove any document from Caselines. I think it will be more prudent if we take away that permission from everybody, and if somebody should want something to be uploaded, they can communicate with either me or Irene to upload such documents. Because yes. I'm afraid, I'm so scared that somebody who doesn't know exactly how Caselines work, that they're going to remove documents, and that then we will have some big trouble there.
Yes, it's better if they first communicate with you, because you are more familiar with what you have already uploaded. Right, so if those documents are there, I should think that they should first be removed so that they can, if they are going to add something or are going to be used by that particular party, let that particular party arrange with the evidence leader first before the documents can be properly uploaded.
Another thing about that, my lady, is that there is a process that will be part of my address later on. Not everything that somebody can think about or make an affidavit about is supposed to form part of an inquest. The Inquest Act provides for the kind of documents and so forth that are part of an inquest. And if somebody just load affidavits or whatever on Caselines, then there's going to be a big problem at the end when all the documents have to be entered into evidence.
Yes, and the other thing before I forget, I see also there are some correspondence that have been uploaded. I don't understand why. If there is an email that you want to send to me through my registrar, let it go to the registrar, not it be uploaded. We upload documents that are going to form part of this inquest record.
Yes, that's correct, my lady.
And then just to clarify the issue with regard to any persons who have information regarding the inquest, they must contact the evidence leader, Mr. Late, at the NPA offices.
That's
I hope
correct,
I'm clear. Yes, they shouldn't contact my clerk. Let them go via the evidence leader, right?
That's correct.
Yes. Can we go on record, Irene?
Yes, yes, Judge.
Yes, you may call the matter.
Can I call the matter now?
Yes, you can.
Okay. Calling the live Esidimeni Inquest, case number I-001 of 2021.
Before we start, okay, yes, continue, Mr. Late.
As the court pleases, my lady, as far as legal representation is concerned, the newest information that I have is that I was contacted by the office manager of legal aid in Pretoria, and he informed me that there are a few witnesses who had contacted him. Inter alia, it was Karina Morale, who, according to the previous sitting last week, when was it? Thursday.
Yes.
She was represented by somebody else. I think it was an advocate, Zakwe, who appeared for her. But now and he said he appeared for her pro bono. But apparently she now contacted legal aid, and they have referred all the witnesses who applied for legal aid to their head office, because normally witnesses don't get legal aid, but because of the peculiarity of this matter, in that they can be suspects, some of the witnesses, they are going to deal with it with their head office to afford legal representation to these witnesses. We'll have information about those within this week, but I propose that we can proceed with the witnesses lined up, 4 or 5 still, that don't directly implicate any of the NGOs in the evidence at this stage.
Okay, these are the witnesses from the NGOs.
That's correct, my lady.
Okay.
The witnesses, the first 4, further 3 witnesses that will testify to the decision making at the top.
Oh, okay.
That doesn't include the NGOs.
Okay, and can we find out now, since we adjourned the proceedings, who are new in these proceedings, and also those that were there who requested an adjournment of the proceedings in order that they can be in a position to go into Caseline, invited, so that they can get the documents. Can I just find out?
May it please the court, my lady.
Yes.
I'm joining now at the late stadium in the proceedings. I was briefed by the state attorney on Thursday last week to appear and represent.
Can you please mute your mic? The court is in session. Continue, Mr. Pinar.
Thank you, my lady. I was briefed to appear and represent the witness or potential witness on the consequential list of proposed witnesses indicated as number 8, Miss Hannah Hendrika Jacobus. I did contact Mr. Late, being the evidence leader, and introduced myself to him and informed him accordingly.
Yes. Were you invited on Caseline?
I was duly invited on Caselines by Mr. Late. He sent me the link and I did.
Did you have time to look at the documents?
I have perused some of the documents, my lady. Due to the voluminous nature thereof, I wasn't able to peruse all of the documentation.
Yes, but will you be in a position to proceed today? Because that was the reason why we post. Just that I don't know. You say you were briefed on Thursday.
Yes.
The reason why we postponed for the whole week, it was to give everyone ample opportunity to be in a position to get all the documentation and be able to peruse them before we proceed today. And we were busy with the second witness. That is a witness from Life Esidimeni.
Well, my lady, if at this stage, I'm willing to proceed. I believe, having consulted with my client, I've been able to do that during the past few days.
Okay.
So I would be, if there's a witness that's at this stage partly dealt with, if I can refer to it as such, I have no objection to the inquest proceeding today.
Okay.
Should we reach a stage where I am of the opinion that my client could be prejudiced, I would inform the court accordingly, and if needs be, then proceed with a formal application for a postponement.
Okay.
If that would be satisfactory to your ladyship.
Thank you very much. Thank you. The others, I see there is Mr. Swanepoel.
Yes, my lady, may I come in here? I'm here on behalf of Advocate Foster, Phyllis Foster. Apologies that she can't be here today. I'm standing in for her for the next 3 days. I'm ready, and my surname is Klein. My name is Matthew Klein, like in small. Yes, Klein.
And your initials?
M.
Thank you very much. Yes, there were counsel, those who were there on Wednesday when we adjourned the matter. I just want to, I think that was, is it Mr. Suping and who? Sibara?
That is correct, ma'am.
Yes.
This is the court. Mr. Suping is here.
Yes, Mr. Suping?
Yeah, yeah, I'm here.
Yes,
So,
I just want to find out, were you invited on Caseline? Were you in a possibility, did you manage to look at the documents?
I was not invited into Caseline.
You were not invited, Mr. Suping?
That's correct, my lady.
How did it happen?
I just do not know.
Did you liaise with the evidence leader and my clerk?
I've spoken to them before. The last. Yeah, I've spoken with them before the last sitting.
But isn't it the adjournment was solely for that purpose, isn't it?
My understanding was the adjournment was because there was COVID at Mr. Late's office.
Didn't we say that the others should be given an opportunity to get legal representation, and further that you, together with Mr. Sibara, I don't know who were the other counsel, that they should ensure that they are invited on case lines to familiarize themselves with the documents that are on case line. That is what was it not the case, Mr. Sibara?
I'm trying to unmute my mic. Can you hear me?
Yes, I'm with you.
Thanks, my lady, for the indulgence. Good morning to other colleagues. Look, my lady, amongst others, I can confirm. I think, can you hear me?
Yes, I'm listening.
Oh, okay, sorry. I can confirm that the matter was adjourned today to give us the opportunity to consult with our clients, to be able to peruse documents. And again, there was issue of conflict of interest with government employees.
Correct, yes.
And the advocate Hutamo, who was at that stage representing government employees as well as my client at that stage. So I'd like to put it on record, my lady, that after perusal of the bundles, there are serious issues which I want to place on record. If this is the opportune time for me to do that, or I can do that after all the parties have been introduced. However, my team has been beefed up by Advocate Makani. I'm going to work with Makani. Makani, and I'm going to be working with him. He was.
Can you spell the surname for me?
Makani is M-A.
Yes.
K-H.
Yes.
A.
Yeah.
N-I.
Yes.
Makani N for Norman. That's his initial. My lady, I'm going to perhaps maybe at this point pause and give the others who have joined the opportunity perhaps maybe to introduce themselves. Because after I perused the bundles and after he joined in, we identified serious issues of consent with the proceedings of the 19th of July 2021. That is the Monday last week when the proceeding commenced. So we identify serious disturbing proceedings which we want to bring them to the attention of the court, and which in our view might as well necessitate a postponement for the court to consider them. So I'll give the opportunity, my lady, to the others who joined today. I received a number of calls from colleagues who have joined. I think there were 6.
All right.
Okay.
We will hear that. We'll give you that opportunity. What I wanted you to confirm was among the reasons for the adjournment of this matter to today, it was because the issue of not having familiarized yourself with the documents that have been uploaded on Caseline was also there.
It was among the reasons.
Yes, correct. I was surprised as to why Mr. Suping is now saying he was not invited on Caseline. All right. Can you all now introduce yourselves?
My lady, I'm Advocate Rendani Munjere. Can I proceed, my lady?
I hear somebody's talking. I can't see the person.
Can you see me, my lady? I'm Advocate Rendani Munjere. Can you see me?
Okay, now I see you. Yes.
Continue. Yes, my lady. I'm representing one of the witnesses who happens to be a government employee.
Yes.
Her name is Mrs. Matloli Defninglovu. She's number 11 on the list of sequential list of proposed witnesses. My lady, I was briefed to represent this witness on Thursday, the 30th of July in Kanu. I was duly invited to the case line on the same day in the afternoon. But unfortunately, my lady, due to the voluminous document in the case line,
we're having problems. We can't hear you properly. Yes.
Oh, okay. Sorry, my lady, for that. I was saying, due to the voluminous nature of the documents in the case line, I was unable.
We can't hear you. I don't know. We can't hear you.
I don't understand.
You might have to sort out your device.
I don't know. Okay. Can you hear me now, my lady? Am I clear now?
You can try.
Okay, my lady. I was saying, due to the nature, due to the voluminous nature of the document,
you still have a problem.
I was unable.
Yes, I think you're breaking.
I don't know what is wrong here now, because I'm using a Wi-Fi here for my office. I don't know what my problem is.
Yes, Judge. Advocate Munjelele, just make sure that the buttons on your laptop are not pressed, because it sounds as if your voice is on fast forward. You're speaking fast. Maybe there's a button on your laptop that is pressed by mistake. Maybe you don't see. But I'll advise that maybe leave the meeting and join the meeting again. Maybe the problem will be sorted out. But just make sure that the buttons on your laptop are not pressed.
Okay, thank you so much, Sharon, for that.
Yes, let's find out what is the option. Are you going to join again, or Miss Mujalele? Miss Mujalele, can you hear me? Okay. Anybody who wants to introduce themselves?
May it please the court, my lady.
Yes, continue.
I am Advocate Koko, my lady. My lady, I was briefed on Thursday by the state attorney. I was not aware that the proceedings are today. What I was told was that I need to consult with the potential witness, Rochelle Gordon. I'm not on case line. I have not consulted. In fact, I was supposed to consult today at 10 with the witness. I heard this morning that the hearing is today, and I made sure that I appear. I've spoken with my colleague, Advocate Late, earlier on, and he advised me that today he will not be calling Ms. Rochelle Gordon. She will call her to inform her as to when she needs her. But I felt, my lady, that for me to understand the proceedings, I need to attend. And I also need to have sight of the documents. I'm not on case line, my lady. That I have not arranged with Mr. Late.
Okay, thank you very much.
As the court pleases, my lady.
As the court pleases, my lady.
Yes, I see there is a Miss Manamela.
Ramaimela, my lady.
Is it Ramaimela?
Indeed so, my lady.
Okay, yes, ma'am.
I am briefed by the state attorney, my lady, I appear on behalf of the Mr. Levi Molefi Mosenohi, who is number 5 on the sequential list of proposed witnesses.
Mosenohi.
Yes, my lady.
Yes.
I have been in touch with your registrar. She has given me access to Caseline. I have perused Mr. Mosenohi's statements, part of the transcript for the first day and the last sitting, my lady. I am still busy with the sitting of the 20th, and some of the statements on Caseline I have perused. I have shortly consulted with Mr. Mosenohi, and I will be continuing to peruse as the proceedings go along. So far, I am in attendance, and I don't foresee the need for me to request any stand down, my lady.
Okay.
As the court pleases.
Thank you very much. Yes.
May it please the court, my lady. My surname is Pretorius. I'm briefed on behalf of Mr. Pizzi by Marae Parsons attorneys.
Mr. Pizzi.
Yes, my lady. I do not foresee that I'll be very involved in the proceedings, my lady. He's not on the list of intended witnesses. He has, however, been involved in the whole saga. He is one of his statement is part of the record. So I just want to place myself on record on his behalf, my lady. I have been invited to Caselines, so I do have access to the documentation, but that is as far as my involvement goes.
Yes. Continue. I see all the new faces. You can just place yourselves on record.
May it please the court, my lady. My name is Liesel Mboweni. I was briefed by the state attorney on Thursday to appear on behalf of potential witness number 9, who is Nonteba Cynthia Sinelo, who is who was an official of the department. My lady, I did get in contact with your registrar. I was invited on Caselines. I've perused all the statements as it pertains to my client. I have telephonically consulted with my client, and I'm due to meet with her as well. My lady, I have not perused all the documents on Caselines due to the nature of the documents, but I believe that we will be ready to proceed should my client be called. I will continue to peruse the documents, and should the need arise to request a postponement, I will do so. But for now, I believe that we are well on course to proceed.
Yes, thank you very much.
As it pleases the court, my lady. I appear for Dr. Selabano. My lady, I've been appearing together with Mr. Watt Pringle since the inception of this matter. So I'm familiar with it, and we're read in. But I will be appearing for Dr. Selabano.
You have been appearing with Mr. Watt Pringle?
With Mr. Watt Pringle. I'm his junior on the matter. And I'll be dealing with the matter for the purposes of today.
Okay.
May it please you, my lady.
Yes, I'm listening.
I'm Lawrence Hardis. I was previously on record with my junior, Tenil Govender. We are ready, my lady.
I don't see your face. Who is that? I can't see you.
It's the boardroom, my lady, because we have our witness present. Do you want to receive the witness as well? So she's here. We're all in attendance, my lady, and we're ready to proceed with the cross-examination.
Is that Mr. Hobbs?
Hodis, my lady. H-O-D-E-S, Hodis.
Come again?
Hodis, my lady.
Elders.
Hodis, yes, my lady. We were present on the first day, and then my junior stepped in, and your lady said that the witness has to remain in attendance. She's in appearance, Ms. Mahlangu, the former MEC. So we're all present today and ready to proceed.
Where is Mr. Hobbs?
I'm Hodis, my lady, here in the boardroom.
Oh, okay. And your surname is Elders?
H-O-D-E-S, Hodis, my lady. H-O-D-E-S.
Hedis, okay.
Hodis, H-O-D-E-S. I'm a senior counsel. And Ms. Govender was in my place previously, my lady, and applied for the postponement to today.
All right.
The only change, my lady, is that we've now been instructed by the state attorney as well, Mr. Isaac Chawe, who's taking over responsibility for our fees, but Mr. Kanarak and Mr. Kanarak's firm is still on board because of the conflict between all the various witnesses. So we've advised them to retain, and they need to just clarify that the attorneys are to remain in attendance in this matter, RHK attorneys. They are present, and we are ready to proceed with the cross-examination, my lady.
Okay, thank you very much. Yes, I see there is who is that? Is that
Maite, my lady?
Yes, Miss Maite.
My lady, I appear on behalf of Ms. Sophie Thelma Lengwani, witness number 10 in the sequential list of proposed witnesses, my lady. I have had an opportunity.
This is Sophie Selokani.
Thelma Lengwani.
Thelma,
proposed
yes.
witness number 10. That's correct, my lady. I've had an opportunity to have a telephonic discussion with the witness, my lady. I do not anticipate us seeking a postponement at this point in time. I am still busy perusing the transcript in order to determine if ever there has been any evidence laid in respect of this particular witness, my lady. But at this point in time, I would submit to your ladyship that we are ready to proceed with the matter as things stand.
Okay.
Oh, yes, I have been invited to Caseline as well, my lady, thanks to,
Thank you.
the ladyship's registrar.
Yes, Mr. There is I think, there is another face here.
My lady, yes, Advocate Tiny Sibuku.
I don't see you, but I see there is somebody here. I think he's a man, but I don't. Where are you, Miss Sibuku? I don't see your face.
I'm trying to make myself visible to you, my lady. My lady, can the court see me now?
There you are, yes.
Right. My lady, I am Advocate Tiny Sibuku from the Maisels Group in Sandton.
Yes.
I am approached by the State Attorney in Pretoria to assist Dr. Libete.
Yes.
I have been approached in the third week of August. However, I have not been provided with any of the documents, and neither have you been invited on Caselines, my lady.
Did you contact the evidence leader? Or my registrar?
I only was made aware of your registrar this morning, and I spoke to her and I requested the link because my attorney was battling with his technology on his side, and I have not on my own contacted your registrar, my lady. I have, however, consulted already last Saturday with Dr. Libete. None of us had any documents.
When did you get instructions?
It was just over a week, not in this week, the week before on a Thursday. I don't remember which day.
Yes.
I don't remember which day it was, but it was not last week Thursday, the Thursday before.
Okay.
And my attorney was, according to what he informed me, battling to get documents. Or
how did that happen? They can liaise with the evidence leader and my registrar to be invited on Caseline.
I'm not aware, my lady. That's the information that I received.
Okay, thank you very much.
Thank you, my lady.
Counsel for government, can I request him to address us in relation to how far they went in order to resolve the issue of the conflict of interest?
As the court pleases, my lady, I must put it on record that when we adjourned on Friday, the main reason for such an adjournment was to allow all potential witnesses to be legally represented.
Yes.
As we have indicated, like this, a potential of conflict between the witnesses.
Yes.
And it appears from my learned colleagues that they have indeed been briefed on behalf of the witnesses, The government has given instructions to the state attorney to appoint representatives on behalf of the witnesses. It is only a surprise to us to learn from Mr. Supping that despite all the address that the court has given about the need to familiarize ourselves with the record, and the fact that there was mention of Mr. Late as the evidence leader, as the person to be contacted with, or the court register, Mr. Supping has not made any effort for the whole of last week when he was in attendance. When he was in attendance of the proceedings. So there can't be any mistake about the reasons for the adjournment. And his explanation doesn't sound to be possible in the circumstances. All the other legal representatives, in as much as they have not managed to read through the record as it is voluminous, but like they have made the attempt to read the relevant parts, and they made contact with the relevant witnesses. And as far as the government is concerned, we have done our best to ensure that there is representation on behalf of all interested parties, and then the proceedings should be able to proceed today. There has been sufficient time afforded to all the parties to ensure that the proceedings are ready to proceed today. So as far as we are concerned, we should be in a position to proceed today, as legal representatives have been appointed on behalf of those witnesses that there were issues about aspect of conflict.
Okay, so should we take it that the issue of conflict of interest has been resolved?
Indeed, by virtue of the appointment of separate legal representatives on behalf of those witnesses.
Yes, and then there was also an issue that was raised by, is it Mr. Hedes, counsel, regarding whether, I don't know whether he said whether the attorneys, I don't know of who should be excused. Mr. Hedes, I don't know whether you needed clarity from...
No, my lady, if I may clarify, we are briefed by the state attorney, Mr. Isaac Chow, who contacted us last week.
Yes.
That our attorneys, we believe that it's in the interest of justice to retain our attorneys, our private attorneys as well, because there's a clear conflict. It's to avoid the conflict, my lady. We've made that very clear to the state attorney as well.
All right, no.
Thank you, my lady.
Okay. Mr. Sibara, is it not an opportunity for us to hear from you now?
I suppose
just before we do that, there is a hand here. I've been seeing this face.
My lady.
Yes. Continue. We are listening to you. Are you struggling? What is the problem now?
My lady, I see there are two hands up.
Yes, I can see. Yes, but I was trying to talk to, there is an advocate in the name of, is it Mapanyo?
Yeah, Mapanyo for Bopelong, yes.
Yes. I don't know whether he's...
And advocate my lady.
Yes, we will give you the opportunity, Ms. Mjelele.
Okay, thanks, my lady.
Mr. Mapanyo, are you there or what is happening? I think he's struggling. Can we, in the meantime, hear Ms. Mjelele?
Please.
They might have to check their recordings. There are problems here. Mr. Mapangwa, are you there? Yeah. Miss Mujarere?
My lady, can I just interject?
Yes.
She's just sitting right next door to me. Can I just walk to her chamber?
Please, are there no people to assist her?
No, she's alone. Can I just walk into her chamber?
Okay, you can do that in the meantime. I don't know who can assist this other one, Mr. Mapangwa. Is there someone sitting next to him? Because he seemed to be all over the place. I see a lot of movement, but nothing is happening. Irene, can you assist here? I don't know whether you have got his contact.
Mr. Mapanya. I think he was just on the phone with me saying that he wants to speak. So I asked him that he can just speak when there's an opportunity for him to do it. He seems to be active. I can see he's moving, but I don't know if he can.
That's why a lot is happening where he is, but I don't know what is happening.
I'll try to call him, Judge.
Okay.
Judge, he's saying he's unable to unmute his microphone, so he's going to leave the meeting and rejoin with another device.
Okay, thank you.
Sorry, my lady, I'm back.
Miss Mujarere? Okay, Mr. Sibara, I will give you the opportunity. I wanted to finish with these two counsel who are still here. Mr. Sibara, Miss Mujarere?
Yes, please, the court, my lady. I was saying to the Honorable Court earlier on that I was duly briefed in this matter by the Office of State Attorney on Thursday, the 30th of July, and I was duly invited to the case line. But, my lady, due to the voluminous nature of the documents in the case line, I was unable, my lady, to go through all the documents, and as a result, I was unable to consult with my client properly. And based on that, my lady,
Who are you representing?
I'm requesting. I'm representing Matloli Daphne Ndlovu, who is witness number 11 on the proposed list of witness, my lady.
Daphne Ndlovu, yes.
Yes, and based on that, my lady, I'm gonna be requesting this honorable court to postpone these proceedings, so that I should have ample time to go through the documents and also to properly consult with my client so that she should not be prejudiced, my lady.
Thank you. Do we still, where is Mr. Is it Mapango? Mapanya.
Oh. Hey. Okay, uyu. Uyu.
Can you please mute your mic?
Judge, I think it's Advocate Mapanya. He's back.
Yeah, yes, I'm in now.
Yes, can you please address the court? How do you pronounce your surname? But something is not right. Oh, there is Mr. Sibara.
Hello?
Yes, we are listening.
Can you hear me now, my lady?
Yes, I am here. I can hear.
Oh, pardon me for all this. Let me switch one off. My lady, we have not been into the duration of our LLB. We're not given IT. This virtual baseline systems is a little bit confusing. Pardon me for that, my lady. Good morning, my lady.
Good morning. If you can stay put, I see you are moving up and down. I don't know what's happening. What is the problem? Why can't you just sit at one place?
Yes, my lady. I was trying to get the device to work properly.
Okay.
Judge, can I please assist? He seemed to be, or he's looking out on the other device. That's why there was an echo. He was
Yes, I had logged in with 2 devices. Pardon me for that. I tried to explain that IT is not my strong foot.
Yes, please. Hey, yeah.
As pleases my lady, if I may continue.
Yes, you may. How do you pronounce your surname?
Mapyanya with the MAPH.
Yes.
WANYA, my lady.
Mapyanya. Okay.
Mapyanya, yes.
And your initials?
LM, Rufu Nomboneni.
LM, okay.
Yes, my lady. I can confirm I was invited to Caselines. I have been liaising with my learned colleague, Mr. Peter Lloyd, who is the evidence leader and of the NPA. I've also been further in liaising with your secretary, the very helpful Irene Chipape, my lady.
Yes.
I have perused.
Who are you representing, Mr. Mapyanya?
I'll be representing Bupilong Mashimong, one of the NGOs who were referred MHCUs from Life Esidimeni.
Okay.
Yes, my lady. I have perused saying if my lady could have noted, they are quite voluminous, the master bundle having something like 32,000 pages.
Yes, we are all aware of those documents.
Yes, I'm in a position to proceed today. I've liaised with the NGO and the respective people from the NGO who have written statements, general statements, being item 30, 828, one of the list of proposed witnesses, and in the general statements, item 826. So, my lady, I'm in a position to be able to proceed today. I also heard when my lady was stating that the last occasion we were busy with a witness, a partially heard witness from Life Esidimeni.
Yes.
Yes, my lady. Hence, I can be in a position to be able to continue as of today, my lady.
Thank you very much.
As pleases the court, my lady.
Yes. I take that it was only the new people who introduced themselves. Do we still have everybody who was there when we started?
We are here, my lady.
Oh, Miss Kasim, yes.
Good morning, Good morning.
Mr. Bergen.
Yes, we are ready to proceed. Good morning. Yes, ready. Continuation of talk. Continuation of talk.
Yes.
Ready to proceed, my lady.
Okay. Can I then move to Mr. Sibara and hear his concerns?
As you please the court, my lady.
Mr. Sibara, you are on behalf of
Miss Dr. Manamela.
Dr. Manamela, yes?
I'm appearing together with Advocate Makani.
Makanya.
Makani, yes, as I've indicated.
Yes.
My lady, the court will note that Dr. Manamela, as I've read in a few pages of the case line, she seemed to be, if I can put it with lack of better word, a person of interest.
Yes.
Dr. Manamela, MEC Mahlangu, and Dr. C. Lubane. They seem to be persons of interest, of which I've noted further that these proceedings have covered submissions by other parties on the 19th of July.
Yes.
The court will note that without undermining the capability of Advocate Hutamo.
Yes.
On the 19th of July, my learned colleague put on record that he has not consulted with Dr. Manamela. Notwithstanding that serious concern, the court proceeded.
Yes.
Above all, considering that Dr. Manamela is a person of interest, the court proceeded.
Yes.
Parties made opening addresses. The state advocate late made serious allegations against my client, who at the time was not consulted by Advocate Hutamo, who was representing him. Again, Advocate Hasim, she made serious submissions in her opening address, which covered extensively, quite extensively, the arbitration before the former Chief Justice, Dikamu Seneke.
Yes.
And those submissions were made before Advocate Late could ask the court for that arbitration report to be admitted into the proceedings as Exhibit A. The court allowed that to happen before the report could even be admitted into the record. And amongst other submissions which were made by Advocate Hasim were the findings of Judge Moseneke, as it then was. Which in our view, my lady, I submit that has poisoned the mind of this court before the report could even be admitted. And the basis upon which this report was handed in later, it was not even clearly defined. Furthermore, I've got instructions from my client that when that report was admitted, she was never consulted to give a thumb up. Advocate Hutamo never ran it with her that can we admit this report? The report has already been admitted to these proceedings. She has never been consulted by Advocate Hutamo with the extent and serious conclusions which the arbitrator took against her. And the report has already been admitted.
Yes.
By this court. Furthermore, Advocate Hutamo did not make opening statement on her behalf because she was not properly represented. He had not consulted with her. The court allowed the proceeding to proceed. Once again, Advocate Foster flagged this on the 20th of July. That, my apology, my lady. She put it on record that it seems there's a problem with Dr. Manamela. No cross-examination was made when Criselda testified on her behalf, notwithstanding the fact that serious allegations were made against her.
Yes.
And, my lady, that is clearly shows that there was no proper consultation between my learned colleague and Dr. Manamela. My client informed me that, my apology again, my lady, she forwarded SMS messages to a female colleague who's representing, who's assisting Advocate Hutamo with questions to be put to Criselda for SADC. That was not done. Above all that, my lady, it is our submissions that Annex A was not properly handed into the record. And my client has an objection to that, which was not raised. How can the court then listen to an objection after the court had admitted the document in the proceedings?
Is that what you were told?
My lady, I've noted that Advocate Late.
Yes.
Applied that the proceedings of the arbitrator be handed in as Exhibit A.
Yes, and then?
The court asked all the parties.
Yes.
Mr. Hutamo agreed that he has no objection.
Okay.
Notwithstanding the fact that he did not consult with the client.
All right, continue.
And that was admitted into the record.
Yes.
Now we hold different instructions. And I will therefore humbly request the court to assist us in that regard, how the court will navigate that space. Because in our view, even Advocate Foster noted that there seemed to be a serious problem. That is when the court as well highlighted that, look, I raised this clearly because I've noted there's a problem.
Yes.
And the court, according to my client, discussed the issue of representations on the 12th of June during the meeting.
Yes.
If she's correct about the dates. Having said that, my lady, we have noted further that a witness, Cassandra, has been excused by the court. However, we know that we've got a leg to recall her.
Yes.
We consulted with our client on Saturday and Sunday, so on Saturday.
Yes.
Via connectivity. Very minimal consultation because she needs additional documents. There are emails which are said to have been sent to her, communications by Criselda from SADC. She's, however, no longer within the department. On Saturday, we gave her a huge task to collect documents, which we noted communications and meetings, which dates back to 2015, 4 years ago. She is trying to collect information with very limited resources. Furthermore, on my side, on my own, I managed to navigate and peruse almost 1,000 pages.
Yes.
Since last week, Friday. I need to correct my lady that we were sitting on the 23rd of July.
Yes, correct.
Which was on Friday. Since last week, Friday.
No. We said, are you referring to these proceedings?
No, the proceedings which were given the opportunity, which I was appearing for the first time.
Oh, okay.
Yes, it was on the 23rd.
It was not the 23rd because we said on the 19th, and then we said on the 20th, and then that should be the 21st.
The 21st, my lady.
That was a Wednesday when the proceedings were adjourned. Yes.
It was on a Wednesday. I suspect, my lady, if not Thursday, but it's not an issue. Since the date which the proceedings had been adjourned, I managed to cover 1,000 pages.
Yes.
Amongst others, I've noted that according to the state, they're going to rely on opinion evidence of specialists. We don't know which specialist the state is going to call. I've spoken to my attorney, Mr. Chowe from State Attorney, that we will need expert opinion as well on our side to counter the opinion of the state. That is one thing which we are going to do. Furthermore, my lady, it is not clear from the state how many inquests are they going to proceed out of 141 in view of the statements which the state made in their opening address that by virtue of the passage of time and how the death occurred, pathologists could not ascertain the causes of death except that it was noted as natural causes on the death certificates. It is going to be proper, my lady, very proper, for the state to give us a clean checkbook, not a carte blanche where we just fish around. As we were sitting when we were busy perusing with my client, we don't even know which inquest they're going to proceed with. Which home are they going to proceed with? We don't know at all. And in the interest of justice, in view of the fact that my client is a person of interest, we need to have a structure, a proper structure, which will talk to particular inquest of a particular day and a home which they're going to focus on. That will as well enable us to cut off the preparation time and the perusal. We'll go specifically and focus on proper and relevant pages. Because I've noted my learned colleagues who came into the picture today who are saying they're ready to proceed, notwithstanding 32,000 pages to peruse. That will assist everyone if we can be told that there are 141 persons who unfortunately passed away. Out of 141, the state is going to present evidence on only this inquest. That is going to be very much helpful. Myself, when I'm sitting before you, my lady, I can say it with very good authority that we at least need a week with my client, because we are doing this almost 24 hours, which in my view is not normal, because we have not even touched the arbitrator's report, which the state alluded that the genesis of the arbitrator was to arbitrate between the parties, not in a quasi-judicial proceedings.
Correct.
But now that report has been handed in, we need to sink our teeth into that report. And I can put it on record now that we are going to challenge the admissibility of that report already, because the contents I'm not sure have been admitted yet, because it was only be handed in as Exhibit A. And my worrying factor is that when Caselines testified, she was referring to additional affidavits which were exhibited before Judge Museneg.
Yes.
And those affidavits have already been handed in as Exhibit B. What procedure thereof in terms of section, I noted further, my lady, my apology, that the state is relying on section 235 of the Criminal Procedure Act to hand that bundle. I can put it on record now that at the time when my client was called before Judge Museneg, her legal representations was chased away by the judge. And how can we then admit to such a report? She was not given the opportunity to make her presentations fully. We're not going to admit to that report, my lady, my apology.
Yes.
And we are going to make an application now, which we deem it proper that the court should as well assess it when the proceedings are adjourned, that the entire report of the arbitrator be expunged from the proceedings because it has not been properly handed in. And furthermore, my lady, we have noted with grave concern that the court allowed the proceedings to go on the 19th, when my land colleague Advocate Butamo noted that he has not consulted with my client. And what we have already picked up from my client is that she advised us during consultation that the very same law firm which is briefing Advocate Hutamo, Verksman, it was the very same law firm which was briefed by the government to charge them disciplinary internally. And she felt highly uncomfortable to be represented by him. And she had no any leg to raise that. She further informed us and advised us that on the 19th of July, she could only gain access on YouTube. That was quite an injustice on person of interest. She could only gain access on YouTube. Again, on the 28th, she could only join access on YouTube. She further advised me, my lady, that the court raised a bit of a concern. Why is she not invited on Caseline? Which I believe that was a proper and relevant concern by the court. But it doesn't end there, my lady.
Just before you proceed, okay, you can finish that line.
Yes. On that score, my lady, it is our considered view. We are representing someone of a great interest. I had only a week and few days, let's say 7 days, if not 8, to digest whatever evidence I managed to peruse, which is over 1,000 pages, and make notes because we can't make copies. This master bundle is huge.
Yes, correct.
So we can't make copies. I peruse making notes and as well run to the transcript of the proceedings. I finalized the proceedings of the 19th. I've read the whole proceedings in the transcript.
Yes.
I'm waiting to go into the proceedings of when the other witness testified. I think it's the former CEO of Life Esidimeni. My lady, in view of the above, it will be in the interest of justice because we are representing a person of interest, that we be given enough opportunity, enough time to peruse all the documentations. And we are very much indebted to the court for the opportunity we're given. We realized the mountain we are climbing, it was higher than Mount Kilimanjaro. When we receive Caseline invitation, I try to go on the handy hint of the state, which Advocate Late did me a favor. But that handy hint, my lady, is designed to assist the state in its own case. Let me come back to a very interesting aspect, my lady, which I want the court to ponder about. During the consultation with my client, it became apparent, I want to put on record, that there's a likelihood that the former Minister of Health, he might likely be a person of interest and is not represented before these proceedings. And further that, I've noted my learned colleague, Advocate Ramaimela.
Just a second, the former MEC of Health.
Dr. Aaron Muchwaredi.
Yes.
I'm doing this to assist the court because I don't want this proceeding to stop and start.
Yes.
I've noted that my learned colleague, Advocate Ramaimela, is representing Mr. Musinohi.
Yes.
I would like to put on record, my lady. Mr. Musinohi, from my instructions, is that he was the project manager, which was dealing with the Life Esidimeni. And the evidence which we are likely going to proceed with on our side, it might as well make him a person of great interest. I want my learned colleague to take that into cognizance when she does her preparation and assess her readiness at this stage.
Okay.
Furthermore, I want to bring to the attention of the court that my client, I've given her a huge task. Just a second, my lady. Just to assist the court further. just to give a court a bit of a picture. Mr. Musinoki was the project manager of the project which was termed then Termination of Contract Relationship between Gauteng Department of Health and Life Esidimeni and Upscaling Community-Based Mental Health Services. That is what the project was called by the Gauteng Department of Health. He was the project manager. My lady, I want to bring it to the attention of this court that this project team was established by the then MEC of Health, Mr. Dani Mahlangu, who's being represented by my senior advocate Hodes. This project, so this team was comprised of 20 members, including chief directors at the district levels, including CFO. It had 20 members. Once again, on Saturday, this previous Saturday, I gave my client a task to give me the list of all those 20 members who she still remembers. Because these are the persons which are going to be persons of interest. I'm afraid, my lady, that by virtue of the reasons that we came on board far too late in the proceedings, we are just managing the matter as the proceedings are proceedings, which is quite unacceptable. I mean, the family members of the deceased, they want to see this finalized as soon as possible. There are so many parties who want this chapter to be closed.
Yes.
And my client, as I've indicated above, I've noted in the whole recording, the proceedings, all submissions by the state and the Section 27. She is seriously being flagged. And I don't want a situation, my lady, because we are doing this on Caseline.
Yes.
I don't want a situation where a witness will testify today, because that witness will introduce new evidence. I will ask for the matter to stand down for consultation. That is going to be a possibility, because we are fishing in the dark. I saw the list of witnesses.
Yes.
However, their evidence before court then becomes convoluted, because, like, for example, Griselda, she testified before the arbitrator.
Yes.
Now she testified before these proceedings. She's referred back to what she said before the arbitrator. And the relevance therefore becomes a bit disturbing. I have already mentioned, my lady, that we are going to make an application.
Yes.
For the arbitrator's report to be expunged from the proceedings. And if the state intends to use that report, we are going to extensively deal with that report wholly as it is. It will be subjected to serious scrutiny and interrogations. I've noted my senior again, Advocate Pringle SC, made very interesting submissions in his opening address when he was very worried about this report as well.
Yes.
That this report was only a tool to deal with arbitration in respect of compensation.
Yes, that is correct.
And if that is the starting point, on what basis a report which was used for compensation purposes is attached to the proceedings of inquest to determine legal and factual causation in a criminal matter? I don't understand. Further than that, I have reasons to believe this is a formal inquest proceedings.
Yes, correct.
It's not an informal proceedings where documents are just uploaded and handed to a sitting judge to consider the documents. No, the rules of evidence must be followed to the letter. If the state intends to produce a document, they must prove it. If the state wants this court to rely on a document, they must prove it. We're not going to admit documents flying from the desktop to Caseline. These documents are just being printed, uploaded to Caseline. Now they must be exhibits. if the state was intending to run this in this fashion, I think I'm afraid it's not going to be that very easy.
Yes.
I'm indebted to the court, my lady. That is how far I can take, my lady. Advocate Makani, my lady, I've informed the court that joined me precisely on Wednesday. I invited him myself personally into Caseline so that he can be at least up to speed of what is happening. I'll give him the opportunity, my lady, and call him sort of a new member, technically so, to address the court, my lady.
Okay. Is he going to do that now?
He's trying to reconnect. He can move to my side if the court can give me an indulgence to just stand up a bit.
Yes, you can do that.
I'm indebted to the court, my lady.
Are you ready, Mr. Makanya?
My lady, I'm going to be as brief as possible. What my learned friend is, for fear of repeating myself, my lady, I came on record properly on Thursday. We have perused the document, but my lady, I don't think it would be fair to say that given the time that we've been given, we might or we should submit that we are properly ready to proceed. My learned friend has put it very, very well to say the documents are voluminous. The witness that we represent, my lady, is a person of interest, and I have no much to submit to say that we cannot say that we are ready, depending on the time that I came on record, my lady.
Yes.
Yes, those will be my submission.
If I may ask before I give a chance to the others to address the court. If you are saying you are not yet ready, how much time would you need now? Take into account that last week you were given the whole week. And I just want to indicate also that as you're making these submissions, you must also understand that we have been holding meetings and your client, Dr. Manamela, was present all along.
My lady,
yes.
Unfortunately, we cannot undo what has already been done.
Yes.
We wish we could have been part of those meetings. But my lady, I think a question of conflict of interest should have been foreseen then by Advocate Utamo and his team.
Yes.
Probably would not been here today where we are. But my lady, as the question of time, my lady, I know my learned friend has said a very good point to say the family members of the victims, they want finality to this matter. They want your ladyship to pronounce as to whether should they be prosecution or and so forth. But that should not be done in haste, my lady, without allowing the witnesses. They have constitutional right to be represented, my lady.
Correct.
That cannot be taken away from them. But we are speaking about at our disposal. We have what is on the case line. We were also given documents, I think about 50 or so on Friday, on Saturday when we were consulting, that were not part of the documents on case line. There's still other documents that we have requested, as my learned friend has submitted, that there's still other documents that we want, the emails and so forth, so that we can proceed.
Are you the counsel who have been, I don't know whether, if I say, are you the people who have been trying to upload documents?
No, we have not uploaded. We have not uploaded anything. We're just saying.
You are talking about documents which are not part of what is already on case line.
No, we have not.
No. Are you now talking about more documents that you got on Saturday, which is in excess of what is already on case line?
Yes, that is correct. That is correct.
Okay.
Yes, but we did not attempt to.
But you still haven't answered my question.
About the issue of time. I think that I can also be guided by advocates. But I would say in the interest of time, I would suggest about 4 weeks, 5 weeks, but that will. My lady, I don't want a situation where, and my learned friend has said something here.
Yes.
When you look at this, we are trying to, when we start, to run without any interruptions. So
Yes.
in other words, we want to be fully prepared. That's why even a question of 4 weeks, I'm saying that with the on the back of my mind, having an idea that the families of the victims also want this matter to proceed and so forth. But saying 4 weeks, I mean, I don't think it's asking too much. If you're looking at about 33 to 34,000 pages, including what we're still going to get, and I think, my lady, I don't know whether that was discussed in the meetings. I've discussed that with Mr. Sbar to say what he submitted about knowing
Which
as
meeting
to
now? Because you haven't been part of the meetings that we attended prior to this,
Yes.
when we agreed on the date.
That is correct. What I'm saying, my lady, is I'm suggesting 4 weeks with the view that the state will tell us as to which inquest will they be proceeding with, so that we might concentrate on that specifically. In the event we don't finish, we'll try by all means, my lady. If it means we must work the whole day and so forth trying to consult, we'll do so. But we do not want
All
to
right,
say.
let me hear the others.
As the court, please.
Yes. Is there anything that you want to add, Mr. Sibara?
May I speak?
Yes,
my lady?
before you start, Mr. Late.
With reference to the first
Mr.
complaint
Late.
by Mr. Sibara,
Mr. Late.
the opening addresses were exactly what they are, opening addresses. It's not evidence, and I think it's an insult to your ladyship to submit that your ladyship has been poisoned by what is being told to you to your ladyship in an opening address. I am sure, and I've had experience with it, that your ladyship is perfectly capable of distinguishing between an opening address and evidence. Secondly, regarding the record of the arbitration, it was handed in terms of Section 235 of the Criminal Procedure Act, which allows for by mere production of a record, it is allowed as evidence for what is written therein. That is the only evidential value there are.
Can I ask
the only
you
evidence is that what is on record is what had happened in
Mr.
those
Sibara, can
judicial
you
proceedings.
mute your mic?
There's no other
Thank you.
provisions for me to hand in a record of proceedings. And the third aspect I would like to address the court, and I'm going to address the court when I do this other address that I referred the court to, is that he keeps on referring to myself as the state. I'm not the state, my lady. This proceedings is inquest proceedings, and your ladyship is in control thereof. I am not the state. I am not trying to prove anything. All the documents have been provided to yourself for perusal, and the inquest is being conducted by your ladyship. I am only the evidence leader. I'm not the state, as Mr. Sibara so eloquently wants to hang around my neck. This is not a criminal trial. Maybe you should forget that this is maybe you forgot that this is an inquest and not a criminal trial. regarding the request for postponement, I know it's water under the bridge, but the first meeting where everybody was informed that they should get themselves legal representation was already on the 19th of April this year. We are now 5 months further. And still, there are some who don't have legal representation. And when each witness subpoena stated that they should obtain legal representation should they want it. I know it's water under the bridge, but this must go on. This inquest must proceed, and they must fall in as they go. The evidence is clear from the statements. I would submit that they start with the case docket, where all the evidence regarding his client is contained in. The arbitration record is only something extra. When he peruses the statements and the allegations made against Dr. Manamela in the statements, he will have a very good idea as what the allegations against Dr. Manamela is. So I don't think a month's postponement is required. And as far as the legal representatives for the NGO owners is concerned, until witness number 6, do not give evidence about separate NGOs whatsoever. All those witnesses deals with the initial decision taking and the getting off the ground of the closing or the termination of the contract with Life Esidimeni. As the court pleases.
Just before you step down, anything that you want to say regarding the handing in of the arbitration record? You have said something, but I just want you to say something with regard to that in relation to Dr. Manamela and her representation at the time.
At that stage, my lady, there was no objection from any of the parties, including the advocate who at that stage appeared for her on her behalf. Now, Mr. Sibara attacked the capability of his colleagues. Maybe you should get his ethics under the belt and not attacking his colleagues and attacking the credibility of this court, and do his job as a legal counsel for a witness in this matter. That's all that she is. She's a witness that might be a suspect in the matter.
And what would be the status of that record as we see it in these proceedings?
The status of that record is just that what was said in the arbitration proceedings is proof that it was in fact said. The contents or the truth of the contents thereof is not proved by that record. In other words, it can be used for cross-examination of witnesses who had testified in the arbitration if they now differs from the statements or the evidence that they gave at the arbitration. The only evidential value of that record is that it proves that what is contained in the record was said at the arbitration. Whether it's the truth or not, it doesn't prove that.
Thank you. Just a second. There was. Mr. Late, just before I leave you, where are
Yes,
you,
my lady?
Mr. Late?
I'm here, I'm back.
Yes, there was an issue that Mr. Sibara raised with regard to the fact that Dr. Manamela indicated that on the first and the second day of the proceedings, she was on YouTube. If you can elaborate on that or just your comment on that.
I don't know, but that's what she said when I contacted her regarding legal representation.
Come again?
I don't know personally whether it was her, but that's what she told me, that she followed the proceedings on YouTube.
And that is what
she told me that when I called her about legal representation.
Oh, okay. Thank you very much. Who do I start with? I think I would start with Miss Kasim. Where are you? Oh, I see Miss Marriott. I see there is a hand there. Who is that? Is that Mr. Van Bergen?
Thank you, my lady. I'm experiencing difficulties with connectivity, and Ms. Marriott has made her laptop available to me. My lady, as your ladyship knows, I represent the interests of Life Esidimeni.
Yes.
And my only contribution to the present debate really revolves around the rights of the witnesses involved. As your ladyship will be aware, Dr. Mkachwa is presently still presenting his evidence. He has been present at each occasion when the inquest sat. And the second witness from Life Esidimeni, Zanele Buthelezi, has been present since the 20th on each occasion. So these are persons who have made themselves available to come and testify. They have been put in the position that despite they made themselves available, the matter hasn't really progressed. And my concern is that whatever decision your ladyship may wish to take in this matter, that their interests also be kept in mind. They cannot be put in a position where they come back and forth. They are both from Johannesburg. They have come to the offices of the NPA in Pretoria, and I would submit that their position and their rights should also be respected in the decision.
Yes.
As your ladyship pleases.
Thank you very much. Ms. Kasim?
Thank you, my lady. Just for a few points in response to my learned friend, Mr. Sibara. The first is in relation to the arbitration report. My learned friend makes an astonishing and extraordinary submission to this court that you should have no regard to the arbitration report by Justice Moseneke. I cannot understand that at all. The very reason that we are here stems from that arbitration and from the report of Justice Moseneke. I haven't heard submissions as to why that should be not entertained, or that this court should have no regard to it, other than the fact that procedurally, it's a procedural objection to the way in which it was admitted. My lady, as much as you must take into account the representation of all parties, I would urge this court to bear in mind the rights and interests of the families who have been involved in this process for a long time and who have sought legal representation themselves so that they may participate in this proceedings. And the never-ending delays are also a prejudice to the families in this matter. The opening statement was merely that. My learned friend seems to think that the opening statement constitutes of submissions to the court, legal submissions or submissions of evidence, but it's an opening statement. It is meant to set out what evidence will be led through the process of the inquest. And that's important because these are not adversarial proceedings. this is an inquisitorial proceeding. The court is going about a fact-finding mission. It is required to take into account all relevant information that is placed before it. It's not, the outcome of this proceeding is not going to be a finding of guilt or liability on the part of any party. The role and the function of the inquest is set out in the Inquest Act, and your ladyship will conduct herself in accordance with the Inquest Act and make findings in terms of Section 6, and that will be recommendations. At the end of the day, this court will be required to make a recommendation one way or another to the NPA. It will be up to the NPA, as we stated at the very outset of these proceedings, to then decide what to do. Should any of the witnesses, and in this case Dr. Manamela, be a subject of prosecution, they will be able to fully defend themselves at the trial. But what we are now asked to do is to postpone these proceedings for a month because of one witness. And I would urge the court not to allow one witness to hold up these proceedings. We've already been delayed in these proceedings. And as I said, my lady, the families have engaged legal representatives to be present since the outset of these proceedings. Finally, I just want to say that Dr. Manamela was present at the case management meetings that took place before the proceedings began. She was advised by this court to obtain legal representation. She did so. She was represented by Advocate Hutamo. And Dr. Manamela was present during those proceedings when we first began. This belated objection is not something that should hold up the proceedings. I understand that the record is voluminous, and it's voluminous for all of the parties in these proceedings. My lady, I would ask you to bear in mind again the interests of the deceased. 1, 2, that the arbitration report is absolutely central to this inquest, and 3, that these are not adversarial proceedings. Thank you, my lady.
Thank you. Next.
As the call, please, my lady.
Yes, Mr. Hutamo.
Yes, I just want to highlight one aspect relating to legal representation.
Yes.
Her ladyship will note that at the beginning or at the commencement of the proceedings, we were not representing Dr. Manamela as a witness. It was only after engagement or after the court had made a request that she approaches legal aid for assistance. But Mr. Late, on behalf of the NPA, contacted my instructing attorney that the government should take responsibility or should come to the assistance of this witness. And on the 20, her ladyship will recall that the proceedings were then adjourned on a Wednesday to allow arrangements to be made.
But what I don't understand, Mr. Hutamo, when did you indicate to the court that you were representing Mr. Manamela? Was it not on the first day, on the 19th? Remember when I asked, I don't know, there was a time I was asking as to where was Dr. Manamela, because when we started with the proceedings, I wanted to know as to how far was she with legal representation, because the last meeting, the case management meeting that we had, that was when she indicated that she doesn't have legal representation. And I indicated at the start of the proceedings to ask as to what was her situation, remember?
Indeed.
Yes, and then what response did I get?
On the 19th of July, when the proceedings commenced,
yes.
I had indicated that we have been given instructions to represent her.
Yes.
And that emanated from the meeting which we had on the 12th of July. And Dr. Manamela made contact with the government on the 16th of July seeking assistance.
Yes.
And it is indeed correct that from the moment when she made contact with the government, we have not had the opportunity to consult with her.
Okay.
And on the 19th, when the proceedings commenced, we did indicate that we have not yet consulted with her, but we have been given instructions. But like having regard to the nature of the matter.
With regard to the proceeding, what was your response? You said you didn't mind the proceeding.
Well, I have indicated to her leadership that, like, in view of the fact that we have not yet consulted,
yes,
we had expressed the desire that
yes,
in the event when it will then become necessary for us to recall the witness who was about to give evidence, we are going to rely on the record that will be provided. And we reserved the right to cross-examine those witnesses who have already testified, relying on the record.
Yeah.
We had expressed ourselves on to say, in as much as certain information has been given or certain evidence has been given against her or in relation to her, we'll use the record for purposes of cross-examination, which was then the issue of conflict had arisen.
Okay.
And then we indicate that to the court. And on the Wednesday then the proceedings were adjourned and resumed on the Friday. On that day, Dr. Manamela was already represented, or arrangements were made that she be represented. So it's quite unfortunate that, like, her legal representatives are now making a case that they've not had the opportunity to consult with her at all when they were already on board on the Friday. And her leadership will recall that the proceedings then adjourned for the entire week. There's no explanation given that since they were in attendance of these proceedings on the, I just wanted to get, since they were in attendance on the 23rd of July,
yes,
when the proceedings were continuing, they don't give any explanation why for the entire week they have not made any arrangements to consult with their client. So the very reason why they were appointed was to come to her assistance. The issues which they are raising, or whatever evidence that has been presented against Dr. Manamela, is on record. And there's no reason why they have not had any access to Caseline. Her leadership had actually made it quite very clear that, like, the parties, those parties who have not yet access to Caseline should make contact with the registrar. No explanation is not given as to why that contact has not been made for the entire week. And if indeed there are issues which are of concern, why for the entire week they have not made contact with their client? So the request on their part that, like, the matter be postponed for a month is not supported by any reason which is plausible in the circumstances, given the fact that, like, they've been in these proceedings far long enough to have made necessary arrangements to familiarize themselves with the matter, including necessary consultation. And my learned friend has made a good point that, like, they reserve the right to recall any of those witnesses. it is within her right, and which is something that, like, we had previously stated that should the need arise that, like, we recall the witness, we'll rely on the record to recall the witness so that, like, the witness can be cross-examined on certain matters. So all that, like, has to be done now on behalf of Dr. Manamela. Any issue that has been raised or led, or any evidence that has been led, is on record, and if they so wish to cross-examine any part of that evidence, they can rely on the record, and then they can apply to this court that the witness be recalled for that particular reason. I don't see any difficulty for them proceeding with the matter today.
With regard to the issue of the arbitration record and the issues that he raised about you not objecting to the handing in of the record?
My lady, I can't put it better than what Mr. Lade has indicated to this court, that the documents, they are what they are, or what is recorded on that document. The arbitration record does not substitute or will not substitute the need for evidence to be led before this court. So all that is going to happen is that reference may be made to the record, but that record, the arbitration record, does not on its own constitute the evidence. It is for this court to consider whatever evidence that is being put before the court. So it cannot be said that the arbitration record on its own is conclusive of what is contained in it. Evidence has to be led in relation to whatever that could have been said at the arbitration proceedings. So if any issue that, like, needs to be challenged, it will be challenged through evidence. And they have the opportunity to cross-examine any witness on whatever issue that could have been raised, either during the arbitration process or during this inquest.
Thank you very much. Just before I move to another counsel, Mr. Lade, as Mr. Hutamo is addressing the court, I'm just, there is this issue that you didn't deal with regarding the structure. Mr. Sibara raised the fact that we should know as to which inquest is going to be dealt with as we proceed, despite the fact that he has got a list of witnesses. Mr. Sibara,
it's clear, Mr.
just a second.
That Mr. Sibara came in the proceedings at a very late stage.
Yes.
The instruction by the Minister of Justice was that a single inquest must be conducted in the Gauteng High Court, Pretoria, regarding all the deceased mentioned in the inquest, 141 deceased. So it's a single inquest with all deceased as being subjects to the inquest.
Can you explain why you say it's a single inquest? Because all we know is that there are a number of people who died, and these people died under different separate incidents and circumstances and at different places. If you say it's a single inquest, I mean, we should work on a sequence. Isn't it one just
inquest is for all the deceased that are for whom J56 record pages were made out, and they are the subjects of 141 case dockets or inquiry dockets that were investigated by the police and that form part of all the documentation that, in terms of the Inquest Act, has been provided to the Minister as well as to your ladyship. And the inquest is a communal inquest into the deaths of all those people, whether they were in Pretoria or Johannesburg or wherever they were.
But isn't there going to be a sequence? Because these are, well, it's very important that these are people from different places who died in different circumstances.
That's correct, my lady.
Yes. I think that is the question, as I understood from Mr. Sibara, to say there were post-mortems and then in respect of each individual death.
No, it's in respect to each individual death, my lady.
Yes, because the confusion comes when you say that it's one single inquest. So if you
it's the process is a single process.
Okay, yes.
But the findings will be regarding each individual deceased.
Okay.
That's why I prepared 141 J56 forms.
Yes.
Where I identified each of the deceased as I proposed the court's findings at the end of the inquest should be.
But the way I understand his concern is it's how the pattern, how are you going to be dealing with this evidence that you're going to be calling witnesses in relation to each specific death? Mr. Sibara, are you with me? If you can clarify that further.
My lady?
Yes.
Can I?
Just a second. Can we allow him to say something before you respond? You are on mute, Mr. Sibara. You are on mute. Mr. Sibara? You are on mute. Where is
Can you hear me now?
Yes, you can talk now. You are on mute.
Thank you, Malid. I'm not going
just this issue, because I think that's the one that
yes. Yeah, just only that issue.
The leader hasn't dealt with. Yes.
Yes, my lady, the court will note that there are 141
deceased
inquest forms. There are 141 inquest forms.
Yes.
The proposal which I was making to my learned colleague, Advocate Late, notwithstanding the fact that we're not part of the meetings which were held, so as to avoid confusion and we have sequence. For example, if the state is going to be leading evidence of the
let us not call him the state. If we can just say the evidence leader.
The evidence leader. I'm sorry, my lady. I'm talking from the premise of a former prosecutor.
Yes.
The evidence leader, when he is leading evidence, for example, of Takalani home, he's going to say, I am going to be presenting evidence of Takalani home. This inquest, we are only going to narrow it down to the inquest of Takalani home. For example, he acknowledges in the opening address that some of the death certificate make references that this person's died of natural causes.
Yes.
So then we need to narrow it down that, okay, we are going to deal with witnesses or evidence specifically talking to inquest of 100 persons, which we want this court to pronounce on the causal link, not to generalize and boil the whole ocean of 141 or 44, if I'm not mistaken. We need to have clarity on that. I thought maybe I was under the impression when I gained the impression from the court last week that there was pre-trial meetings and all that. I was under the impression that has been narrowed down.
Okay.
So that was my proposal on that.
Okay. Thank you very much. Mr. Lee?
My lady?
Yes.
The inquest is into each and every death of the 141 people.
Yes.
I cannot narrow it down because that is the instruction by the minister that an inquest into all the deaths should be conducted by this court in Gauteng, Pretoria. The in the end, and that is why we have not prosecuted in this matter, and that's why we asked the minister to instruct an inquest in relation to all the deaths because of the lack of a causal link. And that is why we present the evidence and why we have all the people that can assist the court regarding this causal link between each and every death and the possible suspects in this matter. And if the court cannot find a causal link, then the court must make a finding to that extent that the court cannot make a finding or no or whatever. That is the purpose of this court, these inquest proceedings. And we were working as a team on all the evidence. And it's not only the evidence that is going to be led viva voce that the court take into consideration. All the evidence that forms part of the docket form part of the evidence this court can make a decision upon.
Okay.
The reason why certain people are called as witnesses is to try and see whether via the wisdom of all the parties together in the court, information can be obtained that will assist this court. And that's why I'm not the state, I'm an evidence leader, and that's why each of these legal representatives represent a witness in the matter to assist this court to come to a conclusion based on the evidence available by their witnesses.
Yes, there's also an issue that the former minister is not represented. I think this Mr. Hutamo must also assist us here.
The
former minister, the former minister of health, Dr. No.
The national minister of health.
Yes, but Mr. Sibara, you were referring to the national minister.
Let me just connect. Yes, the former Minister of Health, Dr. Arun Mutwadidi. The evidence we are going to present in our side, not on the evidence leader side, might touch him. Furthermore,
come again?
It might affect him.
Okay.
Yes. So that is one of the reasons why we are acutely asking for this postponement, because we've got 20 people to identify and assist this court to come to say, we've got everyone on board, let's hit the road. And let me leave it there, my lady. I'll respond later when others have been given the opportunity.
That's fine.
My lady,
yes.
Dr. Motsoaledi is not part of this inquest. He's not forming part of the case docket whatsoever. And if my learned friend, Mr. Sibara, will go and study the Inquest Act, you will realize that an inquest is conducted on the material provided to the presiding officer by the police at the request of the presiding officer. It's not open for all and clear for all to decide who may be suspects or not. We've done a thorough investigation in this matter, north, south, west, east, in every direction. And Dr. Motsoaledi is not in any way implicated in the death of the deceased.
Thank you very much. Yes, okay. Can we hear? Then I don't think Mr. Hutamo, do you want to say something about this? I don't think it's necessary now. After what Mr. Late has said.
I think Mr. Late has given a proper answer to Mr. Sibara's issue of concern. So okay. There's absolutely no need to deal with that aspect at this
moment.
Yes,
we'll hear Mr. Sibara. Who is next?
My lady, may I be permitted to proceed now?
Who is that?
It's Hodes, my lady.
Mr. Hodes, yes. Continue, Mr.
My lady, I align myself with Mr. Sibara's application, even though we are ready and we have been ready to proceed as a matter of record. My lady, if I may go back and trace a few factual statements in this regard. Firstly, my lady, it's exceptional when you have an inquest after an arbitration. I know of no other instance where this has happened.
Yes.
That's the first defining feature, my lady. And I'm afraid that the people that are keen to proceed with the matter have oversimplified what is a very, very serious case in their endeavors to proceed regardless. We are dealing here, my lady, with at least 141 deaths, what is referred to as a joint inquest in terms of Section 6A of the Inquest Act. One needs to be extremely cautious, my lady, because you might very well find at the end of the day, when dealing with this joint inquest, that there are multiple causes of the various deaths. And by way of example, my lady, one death was, and I can put it factually or speculatively, caused by an overdose in advance. So that's one of the deaths that you're dealing with, my lady. So there will be multiple, let me at least say, it's anticipated there'll be multiple causes of death and multiple persons held responsible. That leads one to the question, my lady, where does the buck stop? If we go back and look at what happened during the pre-trial procedure, I'm of the view, and your ladyship identified it on the very first day, that Dr. Monamela ought to have had representation even at that stage. And your ladyship, mero motu of your own accord, questioned everybody in that regard, and that was the genesis of where we are now. But let's go a few steps further, if I may. Firstly, my lady, it was even apparent today that whilst you were addressing, Mr. Late couldn't hear you and vice versa. So it's not conducive to this type of inquiry. So if we were to delay the matter post-COVID, where we could sit in a court and all be heard, as opposed to all of these challenges that we're having with connectivity, it would serve justice and be appropriate because of the seriousness of this matter. So your ladyship is told by the interested parties and by the deceased families how serious this matter is, and we align ourselves with that. So one cannot rush this matter and accept all the current challenges. They are not in the interest of justice. To go back to Mr. Sibara, let me correct him in one regard. On my instructions, it wasn't the MEC who put the team together. It was the head of department, and there weren't 20 members in the team. There were 22. I have their names, and I'm happy to provide them. But what I said in my opening statement was that it was not her decision, the MEC's decision, and I identified, by way of example, and I even named that the Premier ought to be part of these proceedings, and I made mention of him in the opening address. Similarly, Mr. Sibara has mentioned the former minister. Now, I don't know on what basis that can be excluded by the evidence leader, Mr. Late, because at the end of the day, it's your ladyship's discretion in terms of Section 8 of the Act to determine who should be called as a witness and who should testify. So what we need to do with respect, my lady, my respectful submission, is go back to basics in the pre-trial to determine who are the parties to this, who represents them, and how trial ready they are. One cannot start and then say, oh, you know, we forgot the NGOs aren't before the court. Let's go back and allow them to join. Then we say, fine, you've joined, but you must wait because you're only going to be implicated later on. This has nothing to do with you. But that could never be the case, because it goes back to opening address. It goes back to all the evidence. They ought to have been there from the beginning if we're going to do justice to the matter. Similarly, I made it clear in my opening address that we said other parties were responsible. That even impacted on the doctor in question. I made it very, very clear. There was no response to what I had stated. And I'm not here to protect anybody else. I'm here to see to it as an officer of this court that justice is done. It's not being done with respect because we need to ensure that each party is properly represented and participating in this inquiry from the outset. It would be unfair to proceed now and later on decide, well, at the end of the day, it was the minister who was responsible for all of this, but he hasn't been party to it because Mr. Late says he's not mentioned anywhere. And matters are complicated, my lady, as you saw, and I've read the full record of your ladyship having to curtail Advocate Foster when she took the inquiry beyond the statements that were handed in the inquest to the evidence that was led during the arbitration. And there were issues of relevance and speculation on the part of the current witness that were brought to the fore. So it's a very, very complicated matter, my lady. And your ladyship will remember that both Advocate Watt Pringle and I alluded to the fact that whilst the arbitration findings that we handed in, they can guide you, but we disputed the admissibility of that testimony. And the more Mr. Late said...
Who disputed the admissibility of who?
Of the arbitration findings of the former Deputy Chief Justice Moseneki.
Well, because okay, in your open address,
my lady, at page 32540, your ladyship will find it, and that was piggybacking on the submissions of my colleague, Mr. Watt Pringle.
That was in his opening address.
Yes, my lady. I went after him and yet made it clear that whilst he said you may have regard to it, he was of the view that it's open to reassessment by your ladyship. So
yes,
so exactly.
In any event, we know the status. All of us, we understand and we know the status of that record and also the findings in relation to these specific proceedings.
My lady, I don't know if everybody's in accord on that one, because Mr. Watt Pringle made it clear that it's still open to assessment, and I agreed with him, but nobody else had stated that, and nobody took issue with what we stated.
I'm just relating this point that you are making to the issue of the record of the arbitration proceedings.
Yes, my lady. But it was handed in as exhibit, and nobody said, yes, we agree with Mr. Watt Pringle or Mr. Houdis or anybody else. They all remained silent. So it was left up in the air. But I'm in agreement with your ladyship. And I say to your ladyship that it shouldn't be your ladyship's responsibility to ensure that these issues are addressed now. But your ladyship, Mera Motu, went into the issue of Dr. Monamela being represented and correctly. And my lady, there are multiplicity of conflicts of interest here within the government, and your ladyship picked up on this as well. So by way of example, my lady, I act for the MEC, Kudani Dorothy Mahlangu. I act for her in a personal capacity, but she before was the MEC at the time. Now one must ask the question, my lady, and it's going to be relevant, so I'm going to address it now. When budgetary restraints were introduced by the department, on what basis do they attribute blame to her? And that's why we said it goes up to the Premier, and now we were told today, and I'm not taking any issue with that, it goes even further, it goes to the Minister at the time. So one will have to ask at the end of the day, Malane, it's a political question that has got legal consequences. Where does the buck stop in this inquiry? In other words, who initiated the budgetary restraints that resulted in the people being moved from life Esidimeni would be, in my respectful submission, one of the first questions that you'll have to answer in this inquest. Aligned to that becomes who's to blame thereafter for the way in which it was implemented. And there's no basis in law that I'm aware of where one says, well, it stops at the MEC and it doesn't go to the Premier, or it goes to the Premier but it doesn't go to the Minister. So these are all, with respect, interested parties, and it's foolhardy with respect, and I don't want to get personal because we know where we are now, for one party to say they represent the government.
Yes.
Because as you've just heard, my lady, the project management team comprised of 22 members. We don't know what views each person took. We don't know where it stops. So it's extremely complicated, and I'm afraid that my colleagues are oversimplifying this matter with a view to proceeding regardless. And I want to highlight the problems. I'm going to highlight another one, if I may, my lady. When we had the meeting on the 19th of July, everybody was in accord, and Mr. Leighton and I agreed.
Was it on is it the 19th of July or the 19th of April?
No, my lady, 19th of July. I wasn't allowed.
Okay. That's when we started.
Yes, my lady, day one. When we sat down on day one and we said, going forward, we're going to, it was put forward that would follow a system akin to the state capture, where witnesses would be called, matter would stand down, they'd apply for leave to cross-examine. Then we changed it. And it's a moving object, and we all participated in the process.
Was it changed, Council? it wasn't changed. Who changed it? Because isn't it, I specifically stated at the beginning that I would prefer a witness to start with, to give evidence and finish. But in exceptional circumstances, those witnesses can be recalled. That's how we left it. Even it is what we agreed upon in the case management meeting. That's how I understood it. Otherwise, it's going to create a problem. We are not going to finish these proceedings.
That's how we wanted it as well, my lady. But preferred is not the same as a directive. There ought to be a directive from your ladyship as to how this matter should proceed. And let me go one step further. So we have, by way of example, and I don't intend to get personal, we have worksmen's, Mr. Kutamo acting on behalf of the Premier's office. But the Premier is not in attendance. We have the MEC that your ladyship ordered has to be in attendance. So we need to establish, my lady, who has to be in attendance, whether all the NGOs must be in attendance, whether some of them are, and whether some are or aren't interested parties. But this has never been clarified. And that's why we have the position that we have now, where there's just too much uncertainty as to the way forward. So I believe, my lady, that if we have worksmen acting for the government, they must clarify who in the government they act for, because we hear of all these different individuals. Similarly, if they act for the office of the Premier, they must say whether they act for the Premier at the time and whether he must remain in attendance, because I had specifically, before all of this, directly made mention of him in my opening address. It's not evidence, but I gave a direction as to the manner in which I foresaw this matter proceeding. Now we have Mr. Sibara, who's given you an indication that over and above that, there was a team of 22 people that also took the decision here. It's a project management team, and he's saying those people need to be identified, and in his view are also interested parties. If it's found that they're not, they ought at least to be warned in case they want to have representation to follow the proceedings. But to proceed in their absence, as it happened, we were proceeding in the absence of many NGOs when we began, would be improper and not do justice to the situation. So my respectful submission is that we need to, I would rather, and my proposal would be, never mind 4 weeks, I would say, let's postpone to the beginning of a term and attempt to have this joint inquest involving 141 deaths in an open court where all the parties are identifiable. The process that's being followed now doesn't do justice to the matter and doesn't serve the dignity of the deceased persons on whose behalf we're trying to seek justice, my lady.
Okay, thank you very much, Mr. Haides. Yes, anybody else? Mr.
Thank you, my lady. May I? My lady?
Yes, I'm listening, Mr. Pienaar.
Thank you. I would support the submission of my learned colleague, Mr. Odes, as well as Mr. Sibara. I think it would be proper, having heard, I've come in at a late stage in this matter, but I've heard what has been presented to your ladyship, and I would respectfully submit that it would be proper for the matter to be postponed, and preferably I would support the suggestion that it be postponed to be dealt with in open court. It's going to serve the purposes of transparency, not only for the parties involved in this matter, but for the public at large also, who have an interest in this inquest as such, my lady. But so, and I would also then suggest, having heard what's been said, that there should be it appears to me, a follow-up case management meeting prior to the matter proceeding in open court, and I would suggest the case management meeting should be attended by the parties' representatives in person. And once more, I'm of the opinion the courtroom would be a proper venue in that regard. Because it appears to me at this stage, my lady, that although we are ready to proceed, there are certain inherent problems, and I see it appears to me a major problem exists with regard to the arbitration proceedings.
What is the major problem?
No, I've been listening to the parties. I personally do not have a problem with regard to it, because I regard and I would submit that the arbitration proceedings is a collateral issue at this stage, my lady, and the parties are bound to the response that had been elicited at the time in the arbitration. But be that as it may, I do, just to summarize shortly, I do believe it's going to be to the advantage of this Honourable Inquest Court to have evidence presented in open court, in person, and the issues to be dealt with in open court. It would, I also believe, not only be to the advantage, but it would also curtail unnecessary postponements or adjournments during the process. And this may be the result of hindsight at this stage, my lady, but be that as it may, I still believe that would be to the advantage of yourself, my lady, to the inquest court. At the end of the day, when a finding has to be made with regard to the requirements required by the Inquest Act, if I can refer to it as such. So I think it would be appropriate that I would support the suggestion of Mr. Rodez that it be adjourned, and even if it's until the commencement or the next term, I've got no problem with that, my lady, but I'll leave it in the hands of yourself, your ladyship. May it please the court.
I see it's 12:20. Can we take a 15-minute break and then we'll continue when we resume? Thank you very much.
May it please the court, my lady.
Yes, please the court, my lady.
As it pleases the court, my lady.
1:10.
Yeah, is it? Can we take the lunch break and then come back at 1:45?
Pardon, my lady, are we going to resume at 1:45?
1:45, yes, because we took about 30 minutes.
As it please the court,
15 minutes, ne?
Yes.
Yes.
Judge?
Yes.
I just want to ascertain the two witnesses that are in my office that are from Johannesburg. Can they be excused?
Yes. Maybe we should excuse them for now, and then you will talk to them at a later stage.
When the matter.
Yes, because I think we should deal with these issues.
Okay.
Yes. All right. We're going to adjourn now until 1:45.
As the court, please.
May it please the court, my lady.
Okay.
my lady.
Good afternoon, Judge.
Good afternoon.
Afternoon, my lady.
Yes. Can we proceed taking submissions from those that didn't address the court in respect of the issues raised?
But as I everyone.
Come again, Mr. Sibara? You are now on mute. You are muted, Mr. Sibara. Yes.
Yes, thank you. As I proposed, I'm going to respond.
No, you are not going to. I will give you the opportunity once everyone has addressed the court. Yes, that's why I'm saying those who didn't make their submissions must do them now.
As it pleases the court, my lady.
Yes.
As it pleases the court, my lady, might I address the court?
Yes, you may, Miss Ramaimela.
Yes, my lady.
I keep on calling you Miss Maimela.
I will remind her ladyship.
Yes.
My lady, as Mr. Sibara has indicated, I had indicated to your ladyship that I've done part of the perusal and I am ready to proceed. I have reconsidered my position based on what Mr. Sibara had said, what my learned seniors, Advocate Spinar SC and Holders SC have indicated, my lady. My initial contention of being prepared was solely premised on the fact that having had regard to the documents, my client, Mr. Mosenuhi, was just a witness. He was not a person of interest. And from a cursory perusal of the documents that I managed to look at, it looked by all indications that he was not going to be a person of interest, but merely a witness. Now, having regard to what Mr. Sibara has indicated, that Dr. Manamela may be producing documents before this inquest, and should the court accept those documents, which documents may possibly implicate Mr. Mosenuhi and make him a person of interest, then surely, my lady, in the interest of Mr. Mosenuhi, he ought to be granted the opportunity to go through those documents, taking into account this happened over 5-6 years ago, so that if those documents is made reference to when Mr. Sibara cross-examines him, he has refreshed his memory and he knows what exactly is going to be said about him.
Yes.
Now, based on that, my lady, then it would obviously mean that I am not ready to proceed. I would need to have a look at the documents if the court accepts them, consult with Mr. Mosenuhi, and your ladyship will recall he is number 5 on the list. And so far, the court is already at number 2. So it's not very far from the next chronological witness that has to be led.
In any event, that we don't know, we don't have those documents yet.
We don't have those documents, my lady. I don't know if you will accept.
You are saying in case
in the event
happens, but as of now, you are ready, if I understood you.
That was my submission, my lady.
Yes. Thank you very much.
As the court pleases.
May it please the court, my lady?
Miss Goka.
Yes, court, my lady. Thank you, my lady. My lady.
How do you pronounce that?
It's Goka, my lady.
Goka. Okay.
Yes, my lady. Thank you, my lady. My lady, as I've indicated earlier on that I was briefed on Thursday, I did not have an opportunity to consult with the witness who now I see she is number 7. I haven't consulted with her, and now I have access to Caseline. I have quickly and briefly perused her statement. There's a lot of information in that statement, and it would appear as if the witness that I am representing has always been involved in this whole issue of life Esidimeni. As such, my lady...
This is who, again?
It's Rochelle Gordon.
Okay.
Rochelle Gordon. Yes, my lady. My lady, it's a pity that we are joining these proceedings at this stage, whereas there are already witnesses that have been called. But my lady, what I wish to indicate is that I really, a consultation with her is indeed necessary, because it appears as if she's been involved in the whole process. As such, my lady, as I've indicated that I am not ready to proceed. I need to consult with her.
When did you get instructions?
Last week, Thursday, my lady. And the instruction was just to consult with her. I was not aware that there will be this hearing today. I only became aware this morning, my lady.
Well, okay.
Yes, my lady. Thank you, my lady.
Yes, next. Who's next?
My lady, this is Tiny Subuku on behalf of Dr. Libete again.
I don't see you, Tiny. Where are you?
I'm here, my lady.
Okay.
My lady, I have previously, earlier in the morning, introduced myself, placed myself also in respect of Dr. Libete. After hearing my learned senior colleagues, Advocate Hodes, Pinar, and the submissions by the evidence leader, and I want to align myself with the colleague that spoke and suggested a postponement of 4 to 5 weeks.
4 to 5 weeks. Who said 4 to 5 weeks?
I think it is my colleague.
What I heard was 4 weeks, not 4 to 5 weeks. And what is the reason for that?
My lady, I have been invited to Caselines today by your able registrar, Ms. Irene Chipape. Yes. I have not consulted with Dr. Libete in respect of any of the documents which my learned friend, Mr. Sibara, calls to be labels them higher than Mount Kilimanjaro. And listening to these submissions and presentations by my learned senior advocate Hodes, I do align myself with what he had said in respect of the preparations and the proper running of this inquest. The reason why we think on behalf of Dr. Libete thinks 4 weeks is suitable is because Dr. Libete was very involved in the movement and in attending to some of those incidents where we have unfortunately lost some of those 141 lives affected by the live Esidimeni incident. I submit, my lady, that a lot of documents filed will refer indeed to Dr. Libete and his involvement. I've said also that I did consult with him, but it was never in respect of the documents filed. It was just an overview of what his role was, his involvement, and the extent of his participation. His evidence will straddle the evidence of Dr. Manamela, the MEC at the time, and the current MEC up to the time of Dr. Libete's involvement. So the consultation and the preparation will not only involve what he says to me, but also possibly a consultation with the legal representatives of the other employees of the state who are involved.
Okay, thank you very much.
Thank you, my lady.
Yes.
My lady, it's Matthew Klein speaking.
Yes, Mr. Klein.
My lady, we're not opposing the adjournment or postponement, although it will impact, of course, on the availability of counsel and all that. So we're not opposing it. And just my second and last point is just that it's our position that the evidence leader will be, he would have known who are persons of interest to make known what's about this inquest. So that's all we submit. Thank you, my lady.
Thank you. But before you step down, what do you say about this 4 weeks in case the court is inclined to a postponement of the matter?
My lady, that's the impact of availability will then have to be considered, because we put this down till 13 August. And then there are other matters quickly coming up, it's already come up. So it will impact. And there maybe the evidence leader can engage with the parties to process some other dates that we can have mutual consent about.
Okay.
Thank you, my lady.
Thank you. Yes, next.
May it please your ladyship. My lady, I placed myself on
Mr.
record
Martin,
this morning
yes.
as, yes, thank you, as acting for Dr. Selabano. My lady, we have no submissions to make on the postponement. Just 2 points of clarity. Firstly, your ladyship was referred to Mr. Watt-Pringle's opening statement specifically in reference to the admission of the transcript of the proceedings before the arbitrator.
Yes.
Perhaps if I can just refer your ladyship to where that opening statement portion can be found in the record. It appears at page 30, line 8. I'm not going to take you there now. I'm just giving you the reference so you can actually read what was actually said to the extent that you find that it is at all important in your consideration of the application for a postponement. That's the first thing. The second thing, my lady, is as far as a postponement, or to the extent that you do actually grant a postponement, there is a concern that we have, and I think I share it with Mr. Klein,
yes,
which is that council is reserving itself for, we are reserving ourselves for up to 4 weeks at a time for this matter.
Yes.
And unfortunately, every time there is a postponement, that 4 week stretches, it becomes 6 weeks, 8 weeks, and so on and so forth. And it's becoming increasingly expensive for Dr. Selabano to keep us reserved for those periods of time and to have us available. So to the extent that a postponement is granted, it may be best to follow Mr. Hoda's suggestion that it is in fact postponed to the beginning of a new term where there will be some gap or some delay that allows the parties to actually get their houses in order to ensure that council are in fact available for an extended period of time. My concern is if we postpone for 2 weeks, we've now reserved for 20 days from effectively today forward. We postpone for 2 weeks, now that those 20 days becomes 30 days. And if we postpone again, then those 30 days might become 40 days. And that's just a significant problem in securing the attendance of council. Outside of that, my lady, I have no further submissions.
Okay, thank you. Anybody else before I hear Mr. Sibara?
Yes. May I please respond to a couple of points that came not from my learned friend, Mr. Sibara, but from the others who have been piggybacking on his application. The first is just in relation to the question of the manner of these proceedings, the virtual versus an open court.
Yes.
My lady, in that respect, I'd like to refer the court to a recent judgment by the Supreme Court of Appeal in a case called De Beer versus Minister of Cooperative Governance and Traditional Affairs. And the Safley citation is 2021 ZASCA.
2021?
2021, the year 2021, ZASCA.
Yes.
95.
Yes.
And it was a judgment delivered on the first question of transparency and open justice, which one of my learned friends alluded to. And the court had this to say at paragraph 64. Let me just place it in context, my lady. In that matter, Mr. De Beer and the second applicant had resisted the hearing taking place virtually and raised an objection on the basis that it would be inconsistent with open justice. And the SCA found that this was not correct, that in fact it is consistent. And at paragraph 64, the SCA said the following, and I'm quote, "Litigants may not specify the conditions under which they are willing to have a matter heard and adjudicated. The Constitution, in terms of Section 34, gives everyone the right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court. Section 9(1)(a) of the Superior Courts Act requires that all superior courts must be open to the public. Mr. De Beer and the LFN, that was the second applicant in that matter, did not provide a basis as to why the convening of the hearing in this appeal on a virtual platform to which the public enjoyed access was not a fair public hearing, no one who sought access to the virtual platform was denied it. No evidence was placed before the court to suggest that anyone who might have wished to attend the hearing could not do so on a virtual platform. The parties and their representatives did appear on the virtual platform without evident detriment to the value of a public and open hearing. In the prevailing circumstances, the SCA goes on, as long as the parties, their representatives, the public and the media enjoyed proper access to the proceedings, the requirements of Section 32 of the Superior Courts Act, which requires that hearings take place in open court, are substantially satisfied. Absent special circumstances, proceedings are no less open because they take place on a virtual platform. Indeed, such proceedings may be more accessible to the public and no less open to the parties. My lady, I refer the court to this judgment because there was a submission that we should wait for some period post-COVID in order to convene a physical and in-person hearing. Yes. But we would submit that it's not feasible for us to wait for some indefinite and indefinable so-called post-COVID era when it would be possible to have a physical in-person hearing. And that justice shouldn't be delayed in the meanwhile, when there is a method to address it. And related to that, my lady, you will recall at the outset, it was either on the first day of the proceedings or in the case management meeting immediately prior to the first day, we had requested that the virtual proceedings be streamed on YouTube, and that was to allow families who are located disparately around the province to follow the proceedings and not to require them to be able to have to be physically present in a courtroom. That's the first point in relation to the open court. And then, my lady, with regard to the postponement, I would ask that the court perhaps convene a case management meeting so that we may discuss feasible dates that don't result in a lengthy postponement, and in which some of the procedural issues that have been raised by the parties can be dealt with. It seems to me that a number of the procedural issues can be dealt with formal directives by the court. And that can be done through a case management meeting, and in that meeting we could also deal with the question of the dates and particularly the impact on the teams as a result of this continuous postponement. We don't understand why 4 to 5 weeks is the magic number. We don't understand why 4 to 5 weeks is the magic number for a postponement. But that said, we would ask for a case management meeting to come to a feasible and reasonable schedule for the remainder of this hearing.
Okay. Thank you very much. Anybody else who would like to say something before I go to Mr. Suping? Yes, we are listening.
No, I have nothing to say, my lady, currently.
You have got nothing. I think you can just mute your mic because people are talking in your background. Is that all from everybody before I go to Mr. Just before I go to Mr. Sibara. If I may just find out from Mr. Hutamo, just one thing. Mr. Hutamo, are you there? Mr. Hutamo?
As the court, please, my lady.
Yes, I just wanted to find out who specifically are you representing?
My lady, I'm representing the Premier, as the Office of the Premier, as well as the Department of Health. the provincial government.
Okay. Okay. So you are no longer representing any of the employees?
As I have indicated to her leadership, that due to the concerns of the conflict, arrangements have been made that separate or the witnesses should be represented separately.
Yes. Okay. So you are just representing the office of the Premier and the department?
Indeed.
Okay. Thank you very much. Mr. Sibara, let us hear you.
Thank you, my lady. I've noted that from the submissions of my learned colleague, Advocate Hasim SC,
yes,
it would seem she's no longer opposing the postponement. The submission
is
she made.
Is it what she's saying?
No, I'm just saying from the submission she made now, when she proposed that there should be case management, she seemed to be inclining to a postponement.
Can we confirm that with her, Ms. Kasim?
Lady, I'm not relinquishing my opposition to the postponement. We stand by our submissions. We think that there's certainly for today, the proceedings have been disrupted, and we're not in a position to continue any longer because we've excused 2 of the witnesses. So that's where we find ourselves.
Yes.
But we can use the time to have a case management meeting and to determine how we will deal with this going forward without losing too much of the dates that have already been reserved.
Yes, correct. All right.
Please, let me just quickly respond to what my learned colleague, Advocate Lade, said. He made reference that I was insulting the court, which I think it was just a jest. I'm not going to entertain that one as well. That I'm as well undermining Advocate Hutamo. I think he was not listening when I made my when I prefaced my submissions. I underline it by saying that my submissions should not be deemed as undermining the capability of Advocate Hutamo. So I think he missed that point. Furthermore, my lady, it seems as if the mood in the House, by virtue of the number of submissions which this court had, colleagues are inclined to a postponement. And further than that, my lady, a proper case management structure needs to be developed by your office, and perhaps maybe with the assistance of the evidence leader, Advocate Lade. And the court will note that Advocate Makani, who I'm working with, proposed 4 weeks. We're not saying it's a magic number, as Advocate Asim suggested. We cannot ask for a postponement in the air and leave it for the court to decide. We had to postulate dates which we think we are going to be perhaps maybe ready for the court to apply its mind fairly. It's not a magic number. It was a proposal. It seems as if, my lady, there isn't much to respond to except further. Just a second, my lady. My apology, my lady. Advocate Hudam, suggested that...
Can we ask you to mute your mic? You are interrupting the proceedings. I don't know whose that is.
My lady,
just a second, let me just make sure that the mic is muted.
Sorry.
Is the... Okay, thank you very much. Continue.
As it please the court, my lady. Advocate Hutamo made submissions that he does not understand why an explanation was not given, why we did not consult for the whole week. Once again, I think he was not listening properly. The court will note that I put it on record that we consulted with our client on Saturday. And furthermore, the court
which Saturday was that?
This previous Saturday, my lady.
Okay. While we adjourned that other week, because you had the whole week.
That is correct, my lady. I think the court will appreciate that in this type of proceedings, you can't consult on the space without having perused documents. I had to peruse documents, consult with information at hand. Like I informed the court that I read over 1,000 pages before I consulted. If I were to sit in the office, let the client tell a story, I'll have to go back and reperuse. So that is the idea, my lady. If the court will bear with us, we had only a week and some few days.
Yes.
To peruse 32,000 pages.
Mm-hmm.
For all intents and purposes, I doubt if it can be done in 5 days. And furthermore, take notes, constructive notes, to represent a client who is a person of interest. That is practically on its own, in my view, not easy to achieve. That's why we are here today, and we are being blamed for meetings which were held before we came into the picture.
Who is blaming you for that?
My lady, when we were making submissions, the court was making references that there were pre-trial meetings which were held.
Yes.
I might have used an incorrect word to say we're blamed, but it seems as if much expectations were put on our shoulders in view of the fact that there were previous meetings which were held and which were not present.
What you must understand is that we didn't just start to sit in these proceedings. Arrangements were made. There were meetings. That's what the court meant. I don't know how you understood it. And the reason why the court had alerted you to that was that your client has been present all along. You understand?
I'm indebted to the court, my lady.
Yes.
I think we have covered that aspect. There's no need to deliberate it further. Once again, my lady, I'm going to propose as to align myself further with Advocate Makani and the submissions by Advocate Hodas SC with regard to the time factor. We had in our arrangements or discussions with Advocate Makani that it would be proper that a proper pre-trial conference be held between the parties with timelines, which we then have to report to your office or through your register. The court should issue directives with timelines, which are going to include, for example, Advocate Hodas already informed us that the list of the project, so for the task team is 22. We are going to give that list to you register, and we are going to narrow our evidence with our client in a way of a statement, which in our view, we deem it proper that it should be uploaded into Caseline. And that is going to be done in conjunction with your office, with your register. And to compile such a statement, my lady, it is not just a give and take. It's not easy because we are talking about incidents which took place somewhere since 2014.
Whose statement is you're going to compile the statement of your client?
That's correct, my lady. We're going to compile a detailed statement of our client, and that statement is going to be uploaded into Caseline. That is going to as well be determined by the time frame which this court is going to afford us. However, we have a draft statement from her, which we are going to develop on it. And as time goes by, and when the statement is ready, we'll communicate with your office, with your register, have the statement uploaded into Caseline, and so that when she testifies, and each and every one of us can have access to it, to be able to shape their case as and when she comes to testify. So in view of the above, my lady, we are going to be guided by your directives. And I'm going to propose that if this court is going to grant us a postponement, we should not leave these proceedings without strict directives, so that when we come back for the hearing, we are all ready.
But Mr. Sibara, even previously I indicated, I was clear to say, well, I'm granting this postponement after the parties had requested it for specific reasons. And we are all clear that counsels who were present must be invited to Caseline so that they can acquaint themselves with the record. But still, people didn't do that.
If I just interpose,
you can.
It's unfortunate, my lady.
And the other thing, I also spelled out that, okay, you want to say something, continue.
Yes, I wanted to say something, my lady. It's unfortunate. I'm talking from my own point of view and Advocate Makani, who we are representing Advocate Manamela.
Yes.
So from the persons who were present last week, I think we have tried to cover a huge amount of ground, considering that we have already managed to consult. We have identified that there are 22 odd members of the project. The client has managed to draft a draft statement. Just out of a few days, we managed to cover that ground. I mean, I need to put it clearly that my learned colleague, Advocate Utamo, indicated that he was representing my client. From the 19th of July.
Yes, you have said that on record, yes.
Yes.
And that is the basis on which the court proceeded.
And until the date which we took over.
Yes.
He has not consulted with our client. And he is saying to us we should have done magic and consult without even perusing. On that score, my lady, he further on went to say that he placed on record that he's going to use the records to peruse, recall witnesses, and cross-examine thereafter. I've checked the record from the time when he was addressing the court on the 19th. There's nothing like that. And automatically he was suggesting that he was going to delay the court, leave the witness leave, read the record, recall the witness.
Well, that is something that, I mean, it's you who's saying that we cannot say anything about it. We don't know what his intentions were.
It was what he said, my lady. So in view of the above, my lady, it is our respectful submissions and humble request before this honorable court that it will be in the interest of justice that the matter be postponed, proper directives be attended to, and at this point in time, other parties have already indicated that some of them, they joined the meeting today in the morning. And I've got reasons to believe that some of them, they are representing members of the task team.
Yes.
And in view of the above.
Who are these members of the task team you are talking about? I'm hearing this for the first time today. Which task team? The project management?
Yes, the project management team, my lady.
Oh, okay.
We are going to give names. Advocate Hodas SC already has the list of 22 members.
Okay.
We will. I'll contact him and we will liaise with your register, so that those names be uploaded into the case line. Under the title, perhaps you'll decide members of the project team.
Maybe what should happen, you should liaise with the evidence leader.
We'll do that, my lady.
Yes, he's the one that has to check what is it that is on case line or not.
That is, we'll do that.
Otherwise, so that the pagination can be
in line.
Yes, can.
As it please the court, my lady. We are indebted to the court, and with regard to the date, in view of the submissions by other colleagues, it is obvious that if we can just pick up a date, it will disturb other colleagues' diary. We are in the hands of the court for guidance in that respect.
Okay, thank you very much. I see Mr. Late. Do you want to say something, Mr. Ramaimela?
Yes, my lady, before Mr. Late addresses you, perhaps to assist my learned colleague, Mr. Sibara, if he goes to page 1056, which is the affidavit of Mr. Mosenuhi, who I represent, at paragraph 9, he sets out the names of the project.
My lady, may I address the court just shortly on this?
Can we let someone finish and then you'll be afforded an opportunity, please? Don't interrupt while your colleagues are still addressing the court.
Yes, please, the court.
Yes, I mean, Ms. Ramaimela was still addressing the court. I was still to hear the paragraphs that she was referring to.
Judge, may I speak?
Yes.
Judge, I was just trying to ask.
Sorry, my breaking up.
Mr. Late, are you having some problems? I think he has got. Mr. Late?
The sound is breaking up. I just wanted to address the court on this.
Mr. Late?
Spoken project team.
Mr. Late?
Yes, my lady.
Yes. Can she finish and then we'll give you an opportunity?
I see she is muted. So I thought she was finished.
Okay. All right.
As the court pleases, my lady, I was
You
just
have just referred the court to paragraph 9 of the statement of Mr. Msaniro. You said it has got a list of the task team.
Yes,
that it's being referred to here.
Comprised of the project team, yes.
Yes.
That appears at page 1056, my lady.
Yes, I've got that.
That's all I wanted to assist the court with. Thank you, my lady.
Thank you very much. Yes, Mr. Late.
Thank you, my lady. Maybe if Mr. Sibara and my other colleagues started with the case docket.
I think you are not that audible enough. I don't know what's wrong with your.
Is it better?
Just continue talking, I'll tell you.
Yeah. If Mr. Sabara and my other colleagues had just taken the trouble to start with the case docket, they would have seen that statements of all the project team, all the people that were part of the project team form part.
No, I can't hear you.
Maybe I should restart.
Yes, can you change your position?
My lady, can you
hear me now?
Can you ask the gentleman with the mic? Echo.
I see Mr. Hoders is nodding his head. Mr. Hoders, do I have control of this myself? The recording devices, I see you.
No, my lady, I was passing a document to my junior. but I'm in agreement. This illustrates not that we believe that you're not acting in the interest of justice, but just how difficult it is to do it in this medium.
Yes, Mr. Late?
I can hear you now, Judge.
No, not
Can
yet.
you hear me, Judge?
Not yet. Not yet.
Can you hear me?
Yes, just try to talk. I'll tell you.
Can you hear me, my Judge?
Continue talking. I'll tell you. If I can't hear you.
I was referring to the project team that Mr. Harris, SC, and all the other people were referring to. Now, the existence of this project team is nothing new. It is contained in the case docket, together with statements of all the people who were part of this project.
You are still not that audible enough. I don't know, because for the interest. Yes.
I'm going to move to another computer.
Please do that.
Is it better now, my lady?
Yes, let's try it again.
Referring to the project team that my learned friend, Mr. Harris, and the other people were referring to, that is nothing new. It's not something that now came to a fore by Dr. Manamela or somebody else. It's already part of the case docket, and statements by all the people who formed part of this project team is filed in the case docket. So there's not a list necessary to be uploaded to Caselines or whatever. Everything is in the case docket. The people can just read the case docket, and then they will see why the members of the project team, or not all the members of the project team, do not form part of the proposed list of witnesses. So I don't know what this whole issue about the project team is. As regards to the statement that Mr. Sabara wants to upload to Caselines, that is not what Section 3, 4, and 5 of the Inquest Act provides for. The Inquest Act provides for the police to investigate crime, and in the event of an unnatural death, the police should investigate the death, and the statements that were gathered by the police should then be given to the prosecutor, and if he decides not to prosecute, those documents be given to the inquest judge. That is how an inquest works. If they want to provide us with a statement, they must provide the statement to the investigating officer, because it must form part of the case docket before it can be channeled to your lordship or to your ladyship's attention. We can't use documents from all over the place for an inquest. There must be some kind of process by which it's done. Otherwise, it's going to be one big mess.
Yes, and
another thing, my lady, is the aspect Mr. Houders referred to, and that is the expanding issues or expanding possible suspects in the inquest. We have investigated this thing, as I have already said, in all directions. We've requested from the Gauteng government, from Dr. Manamela, from Dr. Mrs. Kadana, from everybody. We requested minutes of the meetings where the decisions were taken to cancel the contract with Life Esidimeni, but to no avail. We didn't receive anything from them. It's the first time since the investigation started, and after several discussions between Ms. Musvango and the investigating officer, it's the first time that we hear that the Premier or that the decision to cancel the contract was taken by the Premier. We haven't heard of that since before the address by Mr. Houders. So if they can provide us with the detail of what a version is in this regard, by all means, I can send the investigating officer to take a statement from the Premier to get his version, and that statement can then form part of these proceedings. Same with the Minister of Health. We can't just summon people or put people on witness list if we don't have statements or anything from them. That is common sense. We can't work like that. So if they can provide us with the details of the meeting and so forth, where the decision was taken, then in the interest of justice, we will definitely follow up on that. But as your ladyship had said, everything must go through me and the investigating officer before we can add documents to Caselines, because actually Caselines is just a filing system for what eventually becomes part of the record of these proceedings. As a conclusion.
Yes, there were issues that were raised by Ms. Kasim with regard to the fact that way forward, at least the matter should be case managed to avoid certain things, because as she indicated, most of the matters are just procedural issues that have been raised. And also the second issue is the issue of raised by Advocate Readiness with regard to the fact that should the court be inclined to a postponement of this matter, the matter must just go to an open court.
My lady, it is in your ladyship's hands to decide how the proceedings shall proceed from here on after. I am quite comfortable either online or in open court.
Okay.
In the end, it's a decision regarding the health of the people, but I agree with Mrs. Asim that we don't know when COVID is going to leave us. So it will be a postponement in the air.
Yes.
If we try to postpone it till COVID is past.
Thank you very much.
Thank you, lady.
If I may, the issues that have been raised by Mr. Sibara, most of them are procedural issues. I must indicate, as I've already told him, that with regard to Dr. Manamela, Dr. Manamela has been present throughout the proceedings, and the record speaks for itself with regard to how she was advised, starting from the meetings, that she has to get legal representation. Even on the first day of the inquest, I clearly wanted to find out as what was her stance with regard to that, and that was when I was told that Mr. Hutamo was had instructions to represent her. Well, with regard to the handing in of the arbitration record, yes, it is already handed in, and there is nothing wrong in doing that, in that all the parties were given an opportunity to object to the handing in of the arbitration record. We know its status as the test that was applied in the arbitration proceedings is not the same as what we are doing now. This is a formal inquest hearing. And like what is happening in the state capture, if a witness feels that the evidence or the question that is being asked, the answering of that question is going to incriminate him or herself, that witness will not be compelled to answer that question if it relates to the evidence that the witness feels is going to implicate him or her. Why I'm saying this in relation to Mr. Sibara's submissions, that there are things that have been said in that record which Dr. Manamela is not happy with. If she is questioned about whatever information that she feels will incriminate her, she is entitled to exercise her rights in that regard. Most of the issues, as I've already indicated, are procedural issues, which issues can be discussed in a case management meeting to avoid things like this happening. I see now I'm addressing you, somebody, it's can I finish, or who is that? I see there is a hand there. I can't see the name. Yes,
My
you
hand
can.
is up. Afternoon, my lady. Are you referring to?
Have you just joined the proceedings?
No, I've always been
yes.
My hand has been up ever since, even when the evidence leader was experiencing problems with his own.
I didn't see it. I see it now because otherwise I shouldn't have left you behind. Yes, continue.
Thank you. If I may just,
Who are you? Because I don't see your face. I just hear the voice.
Oh, can you see me now?
I can't see you. You are not there. That's why I'm surprised.
It's Advocate Mapianya.
Yeah, but you are not there. You can continue because I remember I recognized you. Can I request, please, when you address the court, show your faces?
Can my lady see my face now?
Yeah, well, it's not that visible, but it's fine. Continue. Yeah, it's better now.
It's better.
Yes.
Thank you. Thank you. My lady, the only thing I wanted to address the court on was I'm at idem with my learned colleagues, namely Counsel Russell Barra and his assisting colleague, Advocate Makani, and all other aligned with a postponement on this point. I concur that a postponement in these instances is warranted for, in my case, 3 lives were allegedly lost at our center. The time frame postulated of 4 weeks that they postulated is very reasonable, my lady. For even in my instance, I would like to locate a few documents that I found out that they are not present from the evidence leader in regard to the people that passed in our center. There is missing documents that I will liaise with the evidence leader. And so I feel it would be, for efficacy, my lady, it would be best for all interest parties who are concerned if a postponement is occasioned. I can already see that this is where the inquest is leading today to a postponement. Hence, I would just like to put on record that I also...
You can't read my mind. You can't read my mind. You can't say that.
But yes, my lady.
All right.
That would be all I submit.
Okay. Yes.
Thank you for the opportunity and the indulgence.
Yes. When he interjected me, I had just indicated that most of these issues that are being raised here are procedural issues, and these are issues that can be dealt with in a case management meeting. There is also, before I deal with the issue of a postponement, I want to deal with this issue that was raised by Mr. Hodes, that the proceedings should be postponed and be held in an open court. If I might just indicate that all interested parties who would like proceedings to continue in an open court should make written submissions as to why we should go against the directive of the JP and the minister, taking into account that when we started, those of you who were present when we started having meetings, paving a way to a date to start with the inquest. Initially, it was agreed that the matter was going to proceed in an open court, and unfortunately, given what is happening and for health reasons, that was the reason why. And I don't see any problem as to why we cannot proceed the way we have started. But if there are any more concerns that want to be raised, that can be done by way of written submissions as to why we should go against the directives, as I've indicated. Now, taking into account that we have the second witness that has started testifying and has not yet finished with his evidence, and also looking at all the other parties' concerns, including those who were present when I postponed a matter to a week, like Mr. Suping, who came back to say he has not yet been invited to Caselines. while he didn't even take any effort of contacting anybody. I just want to indicate that we have started with these proceedings, and we started because parties had indicated that they were ready, and all people involved, since we started having meetings, all of them indicated that they were ready to proceed. But given the fact that, well, I do understand that there are volumes of documents that have to be read and the issues that have been raised, I am satisfied that it is in the interest of justice that we postpone this matter. And while we postpone this matter, I also agree that we should hold a case management meeting to deal with certain issues, to narrow the issues as Mr. Sibara, if there are issues to be narrowed, has indicated. I take it that we were all available to sit in these proceedings this week. So we can have a case management meeting this week. Even if we have that meeting on Friday. What is the date for Friday? Friday is the...
Is the 6th, my lady?
The 6th, yes.
6th of August.
And we can have this meeting on Friday, the 6th of August, 2021, and taking into account the council's request with regard to the way forward, should the court grant a postponement in this matter, I am of the view that it is in the interest of justice to give all the parties an opportunity to look at their documents and consult extensively. If we postpone this matter to a further 4 weeks, and then we will resume on the Monday, the 30th of August. On which day, I take it that we're not going to have excuses to be saying that I have just not yet been invited on Caseline, or I haven't consulted properly with the witnesses. I still want to do what? I take it that on this day, we are going to proceed with the matter. I hope I'm clear.
As it pleases the court, my lady.
This
May
will
it please the court, my lady.
This will then end our proceedings for today. And then before I excuse you, with regard to the case management meeting, we will hold that meeting at 10 o'clock on Friday. And it's better to use the same link so that it shouldn't be, I think, another job for Irene now to be inviting all of you to that meeting. That ends the meeting, today's hearing. Thank you very much.
May it please the court, my lady.
Please the court.
Thank you.
My lady.
Yes, please the court, my lady.
Thank you. You are all excused.
Thank you.
Thank you, my lady. See you on the next sitting, my lady, and a good day to you.